anything before I invite Mr. Doherty to make his submissions? No? Thank you, Mr. Doherty. I have just received and had a time to glance through, but no more, your closing outline. Mr. Duckworth, I take it you've received that also?
I have just received it, yes, Your Honour, and I have just sent my own, which is a tiny little bit incomplete, I think, but I hope we'll manage.
All right. Well, that hasn't got to me yet, but no doubt it will before you're called on.
Thank you.
Mr. Doherty.
Yes, Your Honour, thank you. The note I've sent you is, I suppose it's a skeleton of a skeleton. It's a map of what I'm going to be saying this morning. So if you have it to hand, I won't be referring to the note specifically, but it'll let you see where I am in my submissions and what I'm saying. And it should hopefully, for your reference after this hearing, give you some of the key document references that I'm going to take you to if you want to go back and look at them. But as you'll have seen right at the top, in short outline, the claimant says that there are two ways to tackle this. And the first, we say, is that the bank is in breach of mandate and is strictly liable for paying out to the fraudsters. And that analysis is one which is founded on the express terms of the facility and some well-established legal principles, particularly as stated in the Tai Hing case, which I'll come to. And the second, which we say is a freestanding right of action, is that the bank is also liable for a breach of what's commonly termed as its quince care duty, which is its concurrent duty in contract and in tort that says that a bank owes a duty to its customer to act with reasonable skill and care in executing transactions. And in this context, what that means is that a bank will be in breach of that duty where it processes a payment in circumstances where there are reasonable grounds for believing that there's been an attempt to misappropriate funds from its customer. And there's quite a bit to say about each of those, so I'll jump straight into it. You'll see in my closing outline, I begin with the breach of mandate point. And really there are three components to this submission, which is what is the mandate, what's the breach, and finally, what does the law say about where the risk should fall in those circumstances? On the first of those questions, what the mandate is, the starting point before we come to the contractual documents, we say is the account opening form, which is the first time that the bank are told in clear terms what Aegis business was, what transactions it was licensed to undertake, and where it was going to be doing business. And that's a document, of course, Your Honour, we've looked at various points throughout the submissions, throughout the course of this hearing, but the document for your notes at H7, but it's the entries which say that the principal activities of Aegis are coal and firewood trading and raw materials trading and metal ores trading and gravel and stones trading and marble and natural stones trading. So pretty specific. And where it says that its transactions are in UAE, Oman, Thailand, Singapore, Hong Kong, Indonesia, and South Africa, with no reference to Mexico. So that's the background. The starting point for considering what the contract terms are and what the agreed use of the facility is about 4.5 months after the account is opened. We get the 2017 facility agreement entered into on at the end of June 2017. And again, for your note, that's the general terms and conditions document starts at page 23 of the bundle. And the relevant terms, and I can take Your Honour to the page references if you want to look at them. You should have seen them already, and I'll read them out. It's potentially the easiest way. But clause 2.1 of the facility agreement, which for your note is at page 35, says that the lender agrees to make the facility available to the borrower during the availability period, subject to the terms and conditions of this agreement. And then it says that the facility is to be used to utilise and meet the working capital requirements of the borrower. We then get to clause 4.2a of the facility agreement, which deals with the TR facility, and that's at H37 for your note. And that's the provision that says that any advance under the TR facility shall be utilised for imports or local purchase under letters of credit, for making payment to suppliers for the procurement of goods, or for making payments under collection documents, or making advance payment against pro forma invoice for the purchase of goods, provided that the goods are of a nature that the borrower is authorised to deal in as per its existing and valid trade licence. So there are 2 points there. It's 1, goods, and 2, specifically goods that you're authorised to buy in your trade licence. And the trade licence is set out in precisely the same terms as the account opening form, but I've referred to it in the outline document I've provided to you for your note. That's at H5. In addition to setting out what the substance of the facility was to be, there are also certain mandatory terms in the facility agreement about the form of a payment request. And that's clause 4.2c, which again is in the same prescriptive and mandatory terms as 4.2. They both begin with an advance under the TR facility shall. And in this case, it says it is accompanied by the original documents of title, invoices, bills of lading, import bills, or otherwise received by the borrower from suppliers to the goods. And again, I'd stress the point goods. So that's the 2017 agreement. That is then given a further gloss by the documents that are entered into in June 2018, so upon the first renewal of the facility. And the first of those documents that Your Honour has seen already is the 2018 facility offer letter. And specifically, it's the provision that you will find at H90. And what that says is that the above facility will be used for the purposes mentioned in the standby letter of credit issued by ICICI Bank for supply of any goods and services for manufacturing of steel to JSW Steel Limited. And of course, because it's referred to in that document, the standby letter of credit itself is relevant. And again, Your Honour has seen it. It's at, I've given myself the wrong page reference there. I can see if I can correct it. I've got H170 to 171, but I think that's actually the e-bundle reference. But I'm happy to provide that. If you bear with me, Your Honour, I have it elsewhere.
I think it's
H85. H85.
Yeah, in fact, that's the reference you've given in your outline. So.
Oh, excellent. Well, as long as I've got it right there. And we've seen that, and it sets out much the same information. So it says we establish in your favour at the request and for the account of JSW Steel Limited our unconditional standby letter of credit. And then in the following page, we get a description of goods, which says any goods and services for the manufacturing of steel. And in case there was any doubt at all as to the scope following those provisions, which we say are clear, we also helpfully have the supplemental agreement also from June 2018, which is at H95. And specifically, we've got clause 4 of that agreement, which says in very clear terms, the borrower and the lender agree that the renewed facility shall be utilised for the supply of any goods and services for the manufacturing of steel to JSW Steel Limited India. And just pausing there for a second, Your Honour will note that the supplemental agreement is just that. It supplements the terms of the 2017 facility agreement rather than replacing them. And for Your Honour's note, we have a couple of points on that. There's clause 10 of the supplemental agreement, which is at H96. Says the borrower and the lender agree that this supplemental agreement shall be coexistent and coterminous with the facility agreement. And then at clause 11, notwithstanding anything to the contrary contained herein, the borrower and lender agree that all the terms and conditions contained in the facility agreement shall continue to be valid and binding on the parties, save and except to the extent modified herein. Now, if one looks at the language of the supplemental agreement, there are some provisions, including the provision Your Honour has already seen regarding the D&B report, where the way it's structured is to say at clause X of the facility agreement, insert this subclause. That's not what clause 4 is. It's not saying delete and replace. It's supplementing the terms that are in the standby in the original facility agreement. So what that means is that we still have the active provision of clause 4.2a in the 2017 facility agreement, and that is specific to provision of goods that are set out in Aegis trade license. And then a clause and a further clarification on top of that is that that use of the facility then needs to be applied for the provision to JSW Steel in India and for the manufacture of steel. So those points are complementary rather than contradictory. And so the court would invite the court to conclude that the facility contained the following express terms. One, that the facility was only permitted to be used to request advances for the purchase of goods as described in Aegis trade license, which we say, of course, makes commercial sense given that Aegis is a commodities trader and a trader of specific commodities, not specifically for materials. There is also an express term that the facility is further limited to be used for the favour of JSW Steel Limited for supplying goods that were used in the steel manufacturing process. And again, that is a provision which makes commercial sense because Aegis has only got one client and that client does one thing. And then the third provision that we would invite Your Honour to find was an express term is that the parties had agreed that any request for an advance must be accompanied by the requisite documents of title. So that's bills of lading in the course of Aegis business. But even if it were to be something else, one would require there to be, for example, a contract. And before moving on from what those terms were, it is also, in my submission, worth pausing to point out the fact that it was put to and accepted by Mr. Manoram, Mr. Shi, Mr. Trivedi, and Mr. Sebastian, that they all knew what the scope of the claimant's trade license was and what had been set out in the account opening form. They were aware of what the account opening form said about the countries that Aegis was operating in, and they were aware of what the 2018 facility offer letter, supplemental agreement, and the standby letter of credit said about the facility's usage, because they were all aware that Aegis was procuring its supply for JSW only. So, Your Honour, that's the mandate. The next issue that I flagged I'd come to is breach, and we say that the claimant's case is plainly well-founded and that the defendant doesn't really have a realistic answer to it, and we make 3 points on that. The first, and we think it's undisputed fact in this.
I'll just stop you for a moment, just so that I'm clear. At the most basic level, on your case, the mandate was that payments would be made from the TR facility only by an authorised payment request. That's the most basic level.
Yes, that is the most basic level, and that's the first submission on breach, yes. Yes,
but you do put your case at a second level that the mandate was breached by making a payment that fell outside the terms of the facility. For example, on your case, it was not for goods of the requisite kind, which involves that it was agreed between the parties that the bank would only make payments if they fell within those terms of the facility. Is that part of your case, so I can be clear?
Yes. So the parties have agreed that there are parameters for the utilisation of the facility. If a payment is made that falls outside the scope.
No, just stop a bit further. I think that for your case, you need perhaps to say more, that they agreed that the bank would only make payments if they fell within the terms of the facility.
Yes, Your Honour, and that is precisely the case we are making. And I'll come on to this in more detail in the context of Quinscare, but we heard evidence from all of the witnesses who had, as it were, hands-on experience of this, that one of the things that they would do when they received a payment request was to check it to see if it was within the terms of the agreed use of the facility. And it was put to those witnesses and accepted that if it wasn't, the payment would be stopped.
Well, I understand that, but I just wanted to be clear that that was the way you did put your case. It's got at least those two levels, indeed a third level in your 4.3 in your outline. But the second and third levels do seem to require an agreement by the bank that it would not pay unless the payment requested was within the terms of the facility and complied with the form because of requisite documents.
Yes, Your Honour.
Right. Thank you.
Yes, Your Honour. As I said, that's the case we're making, but you're right to observe that our on one analysis we don't even need to go there, because on the first more fundamental level, it's, I think, undisputed fact that the payment requests were unauthorized. That must be the case, because we know that the claimant or its employees didn't send them, and instead the emails were accessed by an unauthorized third party who's forged documents and made off with the funds. And so the claimant's position, which I'll get to when I come on to the law in this area, is that the bank is strictly liable in those circumstances. And then, yes, as Your Honour says, the second point we make is that in this case, the fraudulent payment requests clearly fell outside of the permitted use of the facility, and it was agreed that one, the facility could not be used in that way, and two, that the bank wouldn't pay out on that basis. And we say that one can see that from even the most cursory review of the fraudulent payment requests. And again, Your Honour has looked at it, I may come back to it later, but the Rito invoice, which is at H186, says that the payment was supposedly for mining operations. And that information wasn't only given in the invoice, it was in the email subject heading, and it was in the payment request form. So we can clearly see at least three opportunities there to spot that this is not within the terms of the facility. And then the second payment request, of course, is at 195, but it's Clamour Robotics, and if the clue wasn't already in the name, then it certainly was there in the email subject, the payment request form, and the invoice itself, which purported to be for mining tools and equipment. There's been a reasonable amount of evidence in and around this issue. I think our position is very simple, which is that it is self-evident that Aegis was not licensed to undertake mining operations or to purchase mining tools or equipment. It's equally clear that mining operations or the acquisition of those tools and equipment from what on its face appeared to be a robotics company had nothing to do with the manufacture of steel. Aegis was a commodities trader, as I say, but bluntly, those matters have nothing whatsoever to do with its business. They have nothing to do with the purpose of the line of credit that was granted to Aegis as its working capital. And there can't be any reasonable explanation in that context as to why Aegis would have been paying for mining operations. What commercial benefit could possibly have been derived from that that translated at some point down the line to the eventual onward sale of goods to JSW? The further question beyond that is what conceivable use could either Aegis or its client JSW have had for mining tools, given that neither entity was engaged in mining. Aegis did not run mining projects, it did not finance mining projects, it did not finance mine owners, it didn't buy and assemble mining machinery. It certainly didn't do that from a small office in Cluster G in JLT. And in my respectful submission, the defendant has gone slightly around the houses trying to figure out an answer to this one. The way it was put in each of the witness statements was to say that limestone, pyroxenite, coal and dolomite are mining products. Therefore, I assume by that tangential relevance to mining, the transactions fall within the scope of the facility and the trade license. But that argument fails on a number of different levels. Logically, we say, first of all, it doesn't make sense, and I stand by the analogy that was put to a couple of the witnesses at least, which is that just because a bank is dealing in mortgages doesn't mean that it's dealing in the different layers of business that can come under that. So it's not a house builder, or in the next layer up, it's not an estate agent either. Those are completely separate operations. Here, beyond that analogy, Your Honour is also required to interpret the contractual provisions set out in the various facility documents, in line with the normal principles of construction, which is deriving the ordinary meaning from the words that are actually used. And here, the words that are actually used permit Aegis to use its facility to purchase goods that they're allowed to purchase under their trade license. And that is...
It was put in I think, a slightly more sophisticated way by Mr. Jatinder or Mr. Manaram. Incidentally, what is does either of you know what the correct form of address is?
He goes by either, Your Honour. I think we have been calling him Mr. Maniram.
Okay, thank you. The way I understood him to put it was Aegis might have been paying a mining company to produce mining goods for it, which it would then sell to JSW. I think in a nutshell, that's what it came down to.
Yes, Your Honour. Well, as I say, it was put a couple of different ways. I'm going to come on to deal with that way that it was put, although some of the submissions that I make on the first way that the case was framed, which is what was set out in the witness statements effectively, also has some points that cross over between the two of those. If it's all right with Your Honour, I'll address the points on what's in the witness statements, and then I'll come on to what Mr. Manaram and others said to show how those arguments don't work on any level anyway. So like I say, it's specific to what goods are in the trade license, and for various commercial reasons that makes sense, we say. I think this partly addresses the context of what Mr. Manaram and I think Mr. Shi came on to argue, was that there's some emphasis that's being placed on the use of the word services in the 2018 documentation, if I can put it that way. the argument seemed to be, again, it was put in various different ways, but mining operations is a service that can get you limestone out of the earth, and that's therefore within the facility. But again, I think that analysis falls down pretty quickly. First of all, it's still subject to the claimant acting within the scope of its trade license, because that is still a relevant and active provision of the facility agreement and its agreed usage. And that provision refers to goods and specific goods that are set out in the trade license. So whether or not one agrees with the general proposition that services could include the services of getting some rocks out of the ground, that doesn't really matter, because it still falls foul of the express contractual provisions. Second, and more importantly, is that even if one just views this in isolation by reference to the 2018 documents, services has to be construed in the context of what the rest of the clause says. And what it says is goods and services for the manufacture of steel. And so if you remove the word goods from that provision, what we're being told this is services for the manufacturing of steel. It is not services for the production of raw materials. And those are distinct things. So whilst there may well be a number of complex steps in what the steel manufacturing process is, that process and the services surrounding that process do not include getting rocks out of the ground. Similarly, if one was to take the word services out of there and you're just looking at goods for the manufacturing of steel, when we get to the second payment request, clearly mining tools and equipment can't fall within the ordinary and proper interpretation of that clause, because mining tools are not goods for the manufacture of steel. Mining tools are goods for mining. So we say, as far as the defendant can possibly get with that argument, is to say that mining is in some way tangentially related to commodity trading, because Aegis was licensed to sell products taken out of mining operations. That seems to be where the argument gets to. But it's also important to note that it was put to Mr. Shi, who discussed this issue in some length during cross-examination, and he also accepted that Aegis was not, as a matter of fact, licensed to conduct mining services. And so we say that's relevant too. And Your Honour, that comes on then to the second line of argument, which is the one you refer to, which we say is adopted for the first time at trial, presumably in an attempt to find an answer to this point. But the suggestion that this could have somehow been an advance payment for mining operations so that you can then sell mining products to JSW, we say doesn't work either when you actually look at this. The most obvious point perhaps is that it doesn't say that anywhere in the invoice. It just says mining operations. It doesn't say mining operations for the extraction of pyroxenite, or if that had been the type of transaction that we're talking about, what one would probably expect to see is prepayment for limestone, quantity X, price Y. And again, none of that's there. It just says it's payment for mining operations. So I don't think that one can reasonably apply that sort of assumption to this to say that it falls within the scope of the facility. The argument also doesn't work on its face, because again, when we look at the invoice, it's not saying that it's a prepayment at all. It's actually an after the event payment, because if it was a prepayment, we'd be talking about mine operations for June and July in this 30th of May invoice. But what it's actually telling us is that it's mining operations in March and April. So if this was somehow an advance payment for getting the rocks out of the ground, well, by the time we get to the end of March and April, the rocks are, as a matter of fact, already out of the ground. So it would have just looked like a normal invoice for the purchase of those goods. So the prepayment argument doesn't work there either. Of course, none of those arguments work anyway by the time we get to the second invoice, which is for mining tools and equipment, because you certainly can't run that argument in that case, because mining tools and equipment aren't the rocks that are going to come out of the ground, so it's not a prepayment for that. The only reason you'd be buying mining tools and equipment is if you were going to undertake some kind of mining activity, which I think is agreed by everyone. It's not something that Aegis or JSW, for that matter, were licensed to do. And the only real answer that was offered to that point is that somehow the second payment request was connected to the Redo transaction. I think that was Mr. Shee's evidence. But again, one struggles, even just on the face of it, to see a connection between mining tools purchased from a company in Mexico, which are situated in the USA, which are being delivered to JLT for mining operations that have already taken place in Singapore during March and April. It just doesn't stack up at all. And I think even going beyond all of that, one can go around the houses doing this sort of analysis, but in many ways the key point is that it still doesn't get the defendant to where they need to get to, because what it still fails to address, even if you were willing to accept everything else they say at face value, is that there's still nothing anywhere in any of the fraudulent transaction documents that links this transaction to JSW Steel. So even if you get home on mining operations being close enough to commodities trading, even if you can bring mining tools into the fold by saying that it might have been connected to the mining operations invoice, what is still outside the facility usage is that there is no connection to Aegis one and only client. And that, we say, is the end of it. It's clear, whichever way you look at it, that the fraudulent payment requests are outside of the facility's usage. And then, Your Honour, just to mention, you've already flagged it up, but the final point is the question of form rather than substance, which we've been looking at now, which is it is mandatory language in clause 4.2c of the 2017 facility agreement that an advance shall be accompanied by documents of title. So the evidence that's before the court is that for all of the transactions prior to these fraudulent payment requests, bills of lading were always sent. So that satisfies that requirement. If it's the defendant's case that this was a prepayment for something, and even if that was a permissible use of the facility, the fact is that you would need the documents of title for that payment request to be properly effected under the terms of the contract. And so what that would include is the underlying contract for the goods, which wasn't there. So we say that the defendant's ever-morphing case on this point is something which falls flat and should be rejected. And we say that but for those breaches of the facility, the funds would have never been transferred out to the third party. And that deals with breach. That brings me on to what the law says about who bears the risk in this sort of set of circumstances. And the law in this area is reasonably well established, albeit probably dated on its facts, which is because most of the old line of cases which set out the duties deal with checks which have been fraudulently drawn or not drawn well enough. And I'll come on to a couple of those, but in effect, as a statement of general principle, where a bank effects a payment which is in breach of its mandate to its customer, and we say it's whether because it lacks the requisite authority or just because it's a breach of the express terms of the banking relationship, that the bank will be strictly liable in all but exceptional circumstances. And one of the, I suppose, more modern statements of the law in this area is a Privy Council case, Tai Hing Limited and Liu Chong Hing Bank, still from 1986. But Your Honour will find that case in Bundle G, Tab 1. I don't know if you're looking at it on the electronic platform or if you printed out the authorities, but
I'm looking at it electronically. I have, in fact, looked at it ahead of today. Just see if I can get it quickly. If I am reasonably familiar with that case.
Yes, Your Honour, I'm grateful. The specific part I'm looking at, if it assists, is it's at page G97 of the authorities bundle, and I'm looking at page 106C of the judgment. So it's a Privy Council case, but this is, I should say, English law being applied in the case. And Your Honour is familiar with it, but you'll recall that this is a case about a company's clerk drawing, there's a couple of 100 checks, 300 checks, on which he forged the signature of someone who did have the requisite authority. So it's a case on its facts where the company did not authorise the payments. And does Your Honour have the page reference at 97?
Almost. I hate computers. Yes, I have it.
So it's the section, it begins 3 lines above C, so between B and C.
Yeah.
And it's a point worth stressing because when one is deciding how to allocate risk, it's important to bear in mind the commercial context, which is that the bank makes money from having customers and processing their transactions. I mean, there was a fee for this facility, and there are various other fees and interests that they're generating from this. But what's said in Tai Hing is that the business of banking is the business not of the customer but of the bank. They offer a service which is to honour their customers' checks when drawn upon an account in credit and within an agreed overdraft limit. If they pay out upon checks which are not his, they are acting outside their mandate and cannot plead his authority in justification of their debit to his account. This is a risk of the service which it is their business to offer, and the limits to that risk are referred to, so it's the Macmillan and Greenwood cases, are described as necessary to incidents of the relationship, and it sets out a summary of what the principle is, but I'm going to come on to it. But effectively, offer a service, a customer must take care in the way he draws his check and warn his bank as soon as he knows that a forger is operating an account. But the important principle from Tai Hing is that the risk of fraud as a default position rests with the bank. And if it acts outside its mandate by making an unauthorized payment, it can't hold the customer liable for that when it's been paid out. And we would draw a direct analogy to that case in the first way we've put this breach of mandate claim, which is that the payment requests were made using forged documents by an unauthorized third party, and as a matter of fact cannot have been authorized by Aegis. And so the default position, unless the bank can establish otherwise, is that it bears the risk of having processed those payments. But we also say that the analogy extends to the other ways we put our case as well, because on our further submissions, the bank have still acted without a mandate because they've made payments in breach of the express terms governing the relationship. And once again, it's strictly liable in those circumstances, unless it can bring the case within the limited exception set out in Macmillan, which I understand from my learned friend's skeleton argument is a case that he relies upon. But when one actually looks at Macmillan and some of the subsequent commentary on that, it's clear that it doesn't get the defendant very far at all. Macmillan, Your Honour, I don't know if you're familiar with that particular case, but it's an early 20th century case. The facts are a little different to Tai Hing. It's one of the earlier string of cases that relates to checks. In this case, it wasn't a blank check, but a check that had been filled out in such a way as it left effectively gaps that allowed someone to put in additional numbers and have more paid out than otherwise they would have been able to, and obviously putting the use of those funds to their own nefarious purposes. There was no dispute in the Macmillan case, which I think contrasts to Tai Hing and in contrast to this case, that the cheque was signed by an authorised signatory. So the cheque was initially filled out by someone who had authority to do so, and it was then tampered with.
Why does that make a difference? There was still no authority to pay the increased amount. No actual authority to pay the increased amount.
It's relevant because of the way that Macmillan states the customer's duty in those circumstances, because it's a duty which arises in the transaction specifically. And I'll come on to what Macmillan says about that, and then what Tai Hing has said about that particular point later on. Yeah. So what the way that I'll not take you to this page reference, but it's Lord Justice Finlay's judgment. The way that the customer's duty is described, and this is at 790 of that judgment, is that the customer should not facilitate or almost invite an increase in the amount of forgery in drawing his cheque. But as I say, that principle is actually very limited. So if Your Honour looks at G18, first of all, we'll get the, and this is just by background, this is the general principle of who bears the risk that I referred to at Tai Hing, but this is obviously a much earlier statement of that general principle, but the point is that it's a long established rule of the law. So if you look at, it is just after about 3/4 of the way down, you'll find a sentence beginning with "the whole matter is stated by Best CJ" in 2 sentences. Do you see that?
Yes, I have that.
So after stating that it is the rule that a payment be made without authority, the banker, not the customer, must suffer, he goes on to say, but though that rule be perfectly well established, yet if by the fault of the customer the banker pays out more than he ought, he cannot be called out to pay again. So that's the position effectively that Macmillan follows, which is 1, the default position is that it's the bank, not the customer, that's liable for paying out without authority. And then we come to the caveats to the rule. So if you go on 5 pages further forward, we get the commentary on the exception to the principle, which is at 799 and 800 of the judgment. So it's starting at the paragraph at the bottom of page 799, which you should find on G93.
G22.
G23 is page 799 of the judgment.
Yes, I have that.
And then it's the very bottom paragraph reading, the group of cases to which I've just referred recognise the authority of the decision in Young and Grote, while establishing that it applies only to cases in which the negligence is in the transaction itself, and is no application to cases where the fraud has merely been facilitated by negligence in the custody of the seal of a corporation or of the transfers in blank. Now, the importance of that, and this is why I flagged the difference between Macmillan and Tai Hing in the fact that the cheque had been signed and initially drawn by the customer in Macmillan, which is, for this exception to apply, the negligence of the customer has to be in the transaction. It is not sufficient for the bank to say that there is a more broad duty for a customer to conduct its business operations in such a way as to facilitate fraud. And that was very clear in Macmillan, and it was given the definitive stamp of approval in Tai Hing. So if Your Honour skips forward to page G96, which is page 105 of the judgment.
Yes.
What we have set out sorry, Your Honour, I've taken you to the wrong page reference. It should be G92. Beg your pardon.
Right, yeah, I've got that.
So what we get here is a summary of what the bank were arguing in the Tai Hing case. And I'm looking at between E and F. So it says the bank accept, of course, that both duties exist and have been recognised for many years to be part of English law. Their case is that English law recognises today, even if it did not, 33, an altogether wider duty of care. This is, they submit, a duty upon the customer to take reasonable precautions in the management of his business with the bank to prevent forged cheques being presented to it for payment. And we find, and it's in the analysis from G94, which is 103 of the judgment. It's from E onwards, but effectively the statement of principle that's accepted by their lordships in Tai Hing is set out just between E and F on G94, if you have that.
Yeah.
Which refers to judgment of Bray in National Bank of India. In that case, the judge held that while it's the duty of a customer in issuing his mandates to his bank to take reasonable care not to mislead the bank, there is no duty on the part of the customer to take precautions in the general course of carrying on his business to prevent forgeries on the part of his servants. And the judgment goes on through to page G95 to address and dismiss entirely the bank's argument on this point. So the statement of the law as it is now is that for the Macmillan exception and the Greenwood exception to apply, what one is looking for is negligence in the transaction itself. It is not a wider duty to take precautions against fraud in the normal course of running a business. That's been established by Tai Hing. That has been a rule of law since 1986. Which brings us to the criticism that has been levelled at Aegis in this case, which is a failure to protect its email systems. And I should say that it's not entirely clear that this is exactly how the defendant's case is being put anyway. As I understand it, the issues that were canvassed by the experts related to the issue of contributory negligence. But I think for clarity's sake, it's worth addressing this point in clear terms.
I think it should be addressed because it did seem to me to arise in this context as well as contributory negligence.
Yes, Your Honour. I think probably beyond that, there is probably a pleading question on that issue. Is it pleaded in the defence? But I'm comfortable dealing with it anyway because I think it's pretty clear as a statement of principle, which is that what is being alleged to have been the failure here, and I am going to come on later to deal with the contributory negligence where we'll address it kind of on the facts, but saying that a business needs to protect its IT systems is entirely analogous to what was the broader duty that the bank tried to impose in Tai Hing that was roundly rejected because that attempt to extend the duty on the customer has been rejected for the better part of, well, by the time we got there, it was 70 odd years. And the Macmillan exception can only apply to negligence in the transaction. So that analysis or that exception can't work in this case because there is no negligence in the transaction. The company doesn't issue a transaction, so that's not really the territory we're in. And my submission, the bank doesn't find assistance in the law on this issue. And as I say, I'm not sure it's seriously advanced as a premise anyway, given that the allegations appear to be put slightly differently in the context of contributory negligence. And so, for Your Honour, for that reason, we say that the claimant has made out its claim on breach of mandate. I'll come on later to deal with, and you'll see from the map I've set out, I'll deal with the exclusion issues altogether at the end, because really they apply to all of the way that the claimant has put its case, so it seems to make sense to take those points together. But we would invite Your Honour to find for the claimant on this issue. The bank has acted in breach of its mandate by 1, processing a transaction without authority, 2, by breaching the express terms of the mandate by permitting a transaction that was not permitted under the terms of the facility, and the same point again when it comes to the form of request under the facility, and that there is no exception that applies to the general rule, so it's the bank, not the customer, who bears the risk. Your Honour, unless you have any questions about that at this stage, I propose to move on to Quinscare.
Yes, please.
And you'll see this starts on my roadmap at paragraph 9. But we say this is a freestanding basis of tackling by looking at 3 points, which is first, the nature and scope of the duty, second, why we say the duty was engaged in the facts of this case, and third, why the bank breached that duty, although the third point, in part because of the nature of what the duty is a very short one, which is that in cases where it comes before the court, once the duty arises, it's almost invariably the case that it will have been breached. The duty itself is one which has been said to arise both in contract and in tort. So that would obviously be as codified in the DIFC's law of obligations, but the distinction doesn't really matter for present purposes. I'll come on to what is said in Quinscare about it. We also make the point that this is a duty which is imposed on authorised firms and banks in the DIFC by the DIFSA, which under the DIFC's regulatory law requires its financial institutions to comply with the DFSA's rules. And specifically, we refer to the rules set out in the general manual of the DFSA's handbook in 4.2.2. And really it says the same thing. The defendant or the bank is required to act with due skill, care and diligence. So again, it's a broad statement of what the duty is, but it's analogous to the duty in contract and the duty in tort. If Your Honour goes then to page 117 of Bundle G.
It may help if I say that I am quite familiar with Quinscare too.
I think I might have found one of Your Honour's cases during my research in Australia, although I might be wrong about that. I wondered if it was...
Please remind me.
It's not one, it addressed a different point, I'm afraid, otherwise I'd have referred to it. But at 117 or 376 of the judgment, this is really the classic statement of what the duty is. So at the top of the page from A, we get the analysis which sets out how the term arises, or how the duty arises as an implied term between the contract and the bank.
Your sound is just on. Wait a minute.
Yeah.
What's happened?
Is there something else I can help with?
Sorry, I leant on the keyboard. We had Siri intervening.
Siri might have found the answer. The top of the page is really just setting out the principle of how the duty arises. So it's an implied term in any contract between a bank and a customer that the banker will observe reasonable skill and care. Nothing surprising there. And that the duty in contract and tort are coextensive. And again, it makes the point that nothing really turns on that in the case. And His Honour then set out the competing contractual duty to promptly execute a transfer with the sound public policy reasons, which are that a bank ought not to facilitate fraud, and the attempt really there is to resolve it. But the classic statement is the section beginning at D, where it starts, if the bank executes the order, knowing it to be dishonestly giving, shutting its eyes to the obvious fact of the dishonesty, or acting recklessly, then the bank will plainly be liable. So that's the straightforward statement of whether the liability certainly arises. But in real life, the point is made that such a stark situation seldom arises. And then the critical question is what lesser state of knowledge on the part of the bank will oblige it to make inquiries as to the legitimacy of the order. And there's then a discussion of where the line is to be drawn. The law shouldn't be too burdensome, but on the other hand, it should guard against the facilitation of fraud and exact reasonable standard of care in order to combat fraud and to protect bank customers and innocent third parties. And so holding that a bank would only be liable if there was a lack of probity would be too restrictive. Equally, to only impose liability whenever speculation might suggest dishonesty is impractical. And the compromise lands on that a banker must refrain from executing an order if and for as long as the banker is put on inquiry in the sense that he has reasonable grounds, although not necessarily proof for believing that the order is an attempt to misappropriate the funds of the company. That classic statement was more recently summarised even more succinctly by Baroness Hill in the UK Supreme Court in Singularis, and is set out in exactly the same terms and given the stamp of approval, which is the bank should refrain from executing an order if and so long as it was put in inquiry about on reasonable grounds, believing that there's an attempt to misappropriate frauds. And for your Honour's note, the reference to the Supreme Court's recitation of that is at G477. So what we're looking at here, perhaps unsurprisingly, is the application of an objective test. So we're determining when a banker, acting with reasonable care and diligence, would have been put on an inquiry that an instruction was an attempt to misappropriate funds. And Your Honour, we've heard from I'm coming on to what the standard of care is and the fact that it is engaged, but we have heard from a succession of witnesses on what checks the bank says that it did generally whenever they were reviewing transactions, which we say is relevant to considering one, what a reasonable banker ought to have been doing, and then that follows on to the question of whether the duty is engaged. But a number of statements appear to be accepted and uncontroversial. First, and I list these, I should say, Your Honour, for your note. It's a paragraph 10 under my heading D's review process. But operations and compliance will verify the authenticity of a payment request by examining it together with supporting documents. And you'll note, Your Honour, I've provided you with where this is said and who it was accepted by in cross-examination. So this one is Mr. Shee's witness statement, but accepted by Mr. Manoram, Trivedi and Sebastian. The second is that the bank will determine whether the payment request is in compliance by verifying, by examining it together with supporting documents. So I've taken those slightly out of order. The third is verifying the beneficiary and the country the beneficiary is incorporated in. Fourth, there will be a comparison between prices of goods on invoices and publicly available information. Fifth, operations and compliance will check bills of lading for vessel sanctions or to track shipments. Sixth, there will be a review of ACRA reports for beneficiaries. 7, the operations and compliance and the individuals who reviewed the transactions in this case accepted that they would consider a customer's transacting history as part of their review. Also relevant to that standard of care and what one is to expect of a banker exercising reasonable care and skill are the bank's own policies and training materials in relation to payments. And again, I've given you the page references in my outline, but the policies, by way of example, Your Honour can look at it if you wish to, but I'm happy to read it out because I think it might be easier. First of all, it's section 10.4 of the bank's policies setting out a list of examples of suspicious activities. That's at E406, and which was accepted that operations and compliance staff were trained in and that they would have had in mind when they were looking at a payment request. But that said, that suspicious examples of activities would be transactions that have no apparent purpose or which make no obvious economic sense, where transactions requested by a client are out of the ordinary range of services normally requested or outside of the experience of UBI DIFC branch in relation to a particular client, where the size and pattern of transaction is out of line with any pattern that has previously emerged, and where the client has refused to provide information requested without reasonable explanation. So those are some of those examples in the policies. We also had the training documents, which for your note were E1442. And again, we see much of the same thing. So this is on a slide titled Red Flags Examples. We have right at the top, customer transactions are not in line with his business activities. We've got customer transactions inconsistent with past transaction patterns. We have aggressive contact or pressure from the customer. We have refusal to provide proof of shipment of goods. We have incomplete or no details mentioned on bill of lading. Transactions related to offshore shipments. Transaction instructions are unrelated and by third parties. Party to a transaction is a shell company, and transactions with unusual triggers, such as payment before shipment of goods and without any documents. So we say that all sets out the context in which we consider whether the Quince care duty arises and whether there's been a breach. There are also other matters that we say are relevant context here and relevant to Your Honour's considerations of this case. First of all, it's a point I said at towards the beginning of these submissions, is that the bank's employees who were reviewing these transactions all agreed that they were aware of the scope of Aegis trade license, the account opening form, and the fact that its only customer was JSW. Secondly, we're not talking here about a bank or individuals who are having to review hundreds or thousands of transactions a day with the necessary pace that goes along with that. The evidence we heard yesterday from Mr. Trivedi is we're talking about 10 to 15 transactions, which breaks down, I think, to about 2 an hour, if not less. So we're not talking about high volume trading. Third, we say it's also impossible to divorce what has happened here with what the bank staff would have known about Aegis previous legitimate transaction history. And on that, Your Honour has been referred to a number of different sets of invoices for different beneficiaries. And I provided you with the references for all of those. But we've got Avani, Propel Shipping, Steven Rock, K-Line, Majal Mining, Oldendorf. And what we say is that these have all followed the same format. And I propose to use one example. Your Honour can look at it in the bundle if you wish. It's at page H128 in relation to K-line shipping. But it was a document that Mr. Trivedi was taken to yesterday. And the point we make really is that this document sets out what all of the previous transaction documents also set out. So at the top of the page, we've got who the beneficiary is and all of its contact details. So its phone, its fax, its email, and so on. We've got a list of sets of bills of lading that correspond to that particular invoice. The invoice tells us details of the shipment that we would expect to see, knowing what we know about Aegis business. We've got the vessel name, we know where it's leaving from, we know where it's going to, and we know, perhaps most importantly, what it's carrying, which is limestone, or in other cases coal, or in other cases pyroxenite, and so on. But the point is that it's always there. And what we also have in this particular invoice and in other invoices is reference to JSW Steel Limited as the notified party. And even where we don't have that in the invoice, we have the bill of lading which goes along with it, in which JSW Steel is mentioned.
I think it was more common that the invoice did not have any reference to JSW, although the accompanying bill of lading did.
Yeah, so I can. So
it may not.
Transactions
your point remains that one way or the other there was a reference to JSW.
Yes, and in any event, the remainder of the documents tell us what the goods are, how much they are, what the unit prices are, etc., etc. But just for your note, nothing turns on it, but the two which did refer to JSW in the invoice itself were K-Line and Step-in Rock. But, Your Honour, what we will invite the court to conclude, based on all of the evidence that's been presented and all of the different transaction documents that the various witnesses were taken to, is that there were a number of points which were consistent throughout, which is, first of all, that all payment request forms were filled out by the claimant in a consistent manner. So it will be what its effectively two lines of business were. Either it would be, say, payment for invoice number, which would then correspond to the invoice that was attached, or it would say payment of freight, and that's what's set out on the pro forma request form. The second thing that we will invite the court to find as a matter of fact is that despite superficial differences, all of the invoices for those transactions prior to the fraudulent payment requests followed the same format and were set out in the same level of detail when it came to goods, details of beneficiary, details of shipments, and so on. And the third thing that we'll ask Your Honour to find as a matter of fact is that bills of lading were invariably attached to those invoices, which Mr. Shi accepted in his cross-examination. Before moving on to the next part of relevant, I suppose, context, if I can put it that way, one interesting observation about a number of the transactions, but the K-Line transaction, which I use as an example, is that notwithstanding what Your Honour's views may be about the level of detail set out in that legitimate payment request, which was accompanied by a bill of lading, when one sets that against the fraudulent payment requests, it's notable that that transaction, in fact, was flagged as having certain information that was required and prompted a follow-up. And that's something that we explored with Mr. Javedi in his evidence, but the email requesting further information for your notes at H136. But in that transaction, effectively what appears to have happened is Mr. Trivedi has looked at an invoice which have all of the corresponding bills of lading, which have reference to JSW, etc., and comes back with a query saying the bill of lading doesn't mention K-Line. Can you please clarify? And what we would say is that that's indicative of the sort of due diligence one would expect a reasonable exercise of care and skill to have led to. And it's not only that transaction, there are others where, for example, invoices have been requested for goods on a particular vessel. And that was Mr. Shi at 285, and we've got one from Mr. Sebastian at H 170. And connected to those flagging issues, we also have the linked issue of requests for Dun & Bradstreet reports. And Your Honour, there are a couple of threads to that issue. The first is a contractual point, which is from June 2018, it was included at the bank's request as a requirement of the facility that DNB reports or other credit reports for transactions exceeding $100,000 would need to be obtained. It's not disputed that the express terms of the contract say DNB reports or other credit reports. I don't think that that moves the analysis forward any, because I don't think that there is a suggestion anywhere that there were other credit reports that were obtained. There are mentions to other types of reports being obtained, like World Check and so on, but it was accepted in evidence that those aren't credit reports, so wouldn't be caught by that anyway. But even when one puts aside the contractual issue, what we then have is the issue regarding what happened in fact in relation to these reports. And what the claimant says about that is that the documentary evidence suggests that the claimant was requesting DNB reports before particular transactions were effected. And I've given Your Honour document references to that. And that there was a practice whereby an undertaking would be provided by the company to provide one in due course. But the point really is, at what point in time is the request sent? Because what we say is it doesn't matter when in time the report is provided, but if the request had been sent, for example, when the Rito payment transaction request was sent by email and there had been a response saying, can you provide a DNB report, that's another opportunity effectively to prevent the fraud, because it would have given Aegis the opportunity to respond and say, we haven't requested this. So that's the it's important not to get too lost in the contractual terms when it comes to that particular issue.
If in fact a request had been made, it would have been diverted by the fraudster anyway, wouldn't it? To judge from the diversion of the insufficient funds email.
Well, I suppose it's possible that it may well have been, but if that was the case, what the evidence suggests is that, and I think it's in Mr. Shi's evidence, he says that an undertaking would be provided. So one would presume that the bank would still seek the undertaking. And
your submission would have to be that in that event the bank would still not pay unless and until it received an undertaking, which it would not, because the request for the report would not have got to Aegis. That must be your submission.
Yes, that is my submission. It's to say that the point isn't whether or not the report comes before or after the transaction. The issue is whether or not the request is made and the undertaking is provided before the transaction is processed. So that's how we say the analysis works. So if there wasn't a response by email because it had been diverted to another mailbox, one might expect that the bank would pick up the phone and make the same request, for example. So that's the way we view that. And then the final piece of contextual evidence before I come on to the broader breach issues is the evidence about the process, the payment process itself, and what the claimant will invite Your Honour to find on that issue is first that the standard procedure for issuing instructions was by fax, and that we can see that that's true of all transactions bar one in 2019 where there's a fax error. And we would say that that plainly contrasts with the evidence during the same window of time in 2019, where we can see that the emails that were sent attached documents, including the payment request form, in a Microsoft Word format. So that's a request form that could not have been signed, and therefore is not the type of instruction that could have been acted on. And so when the company were sending their request and the signed request, that's by fax, and that is what's understood to be the process. And I've given Your Honour the document references for that as well. It's E525 and 523. The second finding that we would invite the court to make is that there were no instances prior to the fraudulent payment requests whereby a request would have been submitted by Aegis by email alone or effected by the bank by email alone. So they're always confirmed by at least one other means. We've got the fax, and then we've got email or call, or we've got, most often we say all three, but at very least some combination of the two. So the point is that a transaction is never processed on the basis of an email instruction alone, and the first example that we find of that actually happening is on the 30th of May 2019. And then the third finding that we'd ask Your Honour to make is to accept Mr. Agarwal and in particular Ms. Kurtzoba's evidence on these points in the payment process in particular, which were, in my submission, clear and persuasive, but perhaps more importantly than that, based on a thorough audit of the documentary record, which comprised, thousands of pages of emails and fax records to piece all of this together to tie into the recollection. And we say that that's credible and persuasive evidence. And I would invite you to accept it. Your Honour, that brings me to how the jury's engaged then in the facts of this case. And to be clear, the issue here isn't whether or not UBI carried out the assessments and checks that they say they normally would have, or whether the individuals we've heard from in evidence did suspect fraud as a matter of fact. The question for Your Honour is, would a reasonable banker presented with the fraudulent payment requests and the supporting documents, and in light of the way that they were presented, have been put on inquiry as to a possible fraud? So that's the issue. We're looking at an objective standard. And we say that is undoubtedly the case. And the reason for that is that the fraudulent payment request contains rather a large number of significant red flags that UBI missed, but a reasonable banker acting with due skill, care and diligence would not. And I've listed in broad brush terms what those are in the map that I've provided to Your Honour. And I'll go through those in a little more detail if I may. The first is a point that's already been canvassed, which is that the payment requests were outside of the authorised use of the facility, and that's something which ought to have been flagged. So obviously that's our breach of mandate case, but it's also relevant to whether or not there's a breach of the Quinscare duty. And it's clear that payments for mining operations and tools and equipment fell outside the facility's permitted use. And we say that that didn't even require the bank to look at or study the invoices in any forensic way. It's something that was obvious and ascertainable from the emails, which set out effectively what the payments were requesting in the email subject. And beyond that, and when asked in cross-examination, it's accepted by the defendant's witnesses that none of the fraudulent transaction documents made any reference to Aegis only known client JSW. And given the scope of the facility's agreed usage, that's something they ought to have spotted, and it's also something that on their own evidence they were looking for. The second point is tied to that, which is that the transactions were inconsistent with what was known by the DIFC branch to have been Aegis normal business. So even if one were to adopt the premise, which we disagree with, that the facility could extend to utilization for mining operations in one way or another. The fact is that Aegis didn't engage in that activity, and the bank knew it, and its witnesses accepted that. There were no transactions for mining operations prior to the 30th of May 2019. That was put to and accepted by Mr. Manaran, Mr. Shi, and Mr. Trivedi. And the fact is that what we have is a 2-year transaction history prior to the fraudulent payment request being made, and where we've got what appears to be a new string to the company's bow, or a new line of business. In light of that history, it should have raised queries about why one even of those payment requests is seeking payment for mining operations, let alone 4 being made in quick succession for the first time in the space of around 10 days. The next point we rely on is the inconsistent pattern of transactions that this would have represented. Some of the various explanations as to why the transaction was processed, as I've already raised with Your Honour, is that this may have been part of an advance payment for mining operations. And even putting aside the fact that the invoices didn't say that, it's still inconsistent with what Aegis have been doing for the 2 years up to now. And the training materials that I've referred Your Honour to tell us that it's a red flag where there are unusual triggers for a transaction, such as payment being made before shipment of goods, which is effectively the territory we're falling into here.
Could you tell me a bit more precisely what you say were the inconsistent transaction patterns?
Yes, so what we have is, first of all, the claimant is engaging with new beneficiaries, and I think it's clear from the spreadsheet that Ms. Kurotsova provided, this isn't a business that is engaging with lots and lots of different new businesses. It tends to be the same repeat suppliers that are being engaged. One of the explanations offered by the defendant's witnesses for this transaction and the way it was set out as payment for mining operations is that this was some kind of advance payment, or I can't recall the term that was used for it, but effectively it's a differently structured transaction to anything that had preceded it. So before, what we get is, here are some bulk goods, we are buying them and we are shipping them. They exist. Here's the bill of lading. Here's where it's being delivered to. That's the transaction pattern in the past. And in this case, we've got something which is entirely new, which is seemingly a payment for some kind of operations which might yield some product at some point in the future. So we say that's a different transaction pattern. There are other things as well. So dealing with businesses who on their face are unfamiliar lines of businesses like robotics companies, or dealing in mining tools, we would say is a marked departure from anything that Aegis have done up to that point, as is, for that matter, dealing with parties who are situated in Mexico or who are selling goods which are situated in the United States. So we say that these are all factors which lead to a different pattern of transaction. It's something that ought to have been looked for. And the specific point we make about the payment structure, this advance payment argument, is that is specifically referred to in the bank's training materials as something that is a potential red flag.
All this seems to be possibly within your item 2 of inconsistent with the experience with the customer. There's quite an overlap in that, isn't there?
Yes, I suppose there's an overlap. I think the points I was getting at more with the first submission is the substance of the transaction. So when we look at the previous invoices, we can see a consistent thread. It's X megatons of dolomite, it's X megatons of limestone. It's always following the same substance. The point with the inconsistent transaction patterns is, I think, more about the the mechanism for payment. So instead of paying for goods, you're making an advance payment for goods. And yes, I completely agree with you that it's linked. I'm just sort of making slightly different points, but whether linked or not, I think the broader point we would make is that this should have raised the alarm.
I understand that, but incidentally, they're not megatons, they're metric tons.
Metric tons. Yes,
Yeah.
quite right, Your Honour. I'm not even sure what the megaton would look like. I've forgotten my A-level physics. The next point that I refer to in my outline is that the request is outside the established payment process, and that really follows on from the findings of fact that I've invited Your Honour to make. Really, the point there is that these were not instructed in the normal way. There's no fax, there's no telephone call. The payment request form doesn't follow the standard template. The supporting documents that one would expect to see from an Aegis transaction are not all there. Particularly the bill of lading is missing. The first time that we find a payment instruction acted on in this way is the 30th of May, and that was accepted by Mr. Sebastian in cross-examination, who is the defendant's witness, who's probably closest to this aspect of the defendant's case, because he was the day-to-day contact as the sort of first rung in the ladder, I think, as Mr. Duckworth put it. The next point I make is the failure of the bank's internal processes. So the first is the point which I've raised and I won't go over again, but it's the issue with the D&B reports. So what we say ought to have happened is that there is a request for a D&B report and an undertaking provided before this transaction is going to go ahead. I won't go back over that. Perhaps even more concerning than all of that is the bank's evidence yesterday and the day before on ACRA reports, which Mr. Shi, Trivedi and Sebastian all accepted that they'd looked at. And whatever report one looks at, there's the more detailed report at E758. There's the online version of the report, which is now at J tab 2. Those reports, which were supposedly read, showed that Rideau Pte was an accountancy firm or a firm offering taxation services. And despite the fact that that was looked at, nobody has seemed to have spotted or flagged a concern as to why over $800,000 are being sent to an accountancy firm for the payment of mining operations. And then the final sweep up point I suppose I make, Your Honour, is that there are just other basic due diligence failures here when one actually spends not even that long looking at the documents or the invoices. So these aren't things that take some kind of forensic examination to uncover. It's something we say is obvious on the face. But I have it in front of me now. Your Honour, no doubt will spend some time looking at these. But at 186, the Rideau invoice, one can see from the outset that it looks completely different to anything that's come before it, just setting aside the fact that we've got a new beneficiary. But if we've got a 2-year transacting pattern, one would expect reference to the raw materials, reference to all of those things we've looked at, vessels, ports of lading. We'd expect some reference in there or an accompanying document to JSW Steel, which is accepted, was nowhere in any of these documents. But even if one looks at this at face value and says this is a potentially legitimate transaction within the scope of what the company does for mining operations, we don't have anywhere near enough detail that we would be expecting. There's no breakdown of price or what the services are, or in relation to the robotics invoice, what the mining tools and equipment were, how many items of different types of equipment there were, what the unit prices were, and so on. These are things that the defendant bank has said that it checked. It checked prices against publicly available information. Similarly, if this was an advance payment for the products of mining operations, one would expect to have reference to which product. So it's not sufficient for the bank to say, okay, well, it's mining operations For all we know, it could be mining of gold or diamonds or something that the business is not licensed to engage in. So we lack that detail. We also lack even the most basic details of contacts for the beneficiary, which is, in my submission, highly suspicious. There's no phone number, there's no fax, there's no email address. We don't have the supporting documents of title, whether that be a contract or a bill of lading. We have an example of a pressurizing email being sent a couple of hours after the transaction is requested saying we want this urgently. We've got, on the face of it, a request for a payment in Mexico, which should have been flagged up as being strange. We've got the same date and timestamp used in 3 different transactions, which are effectively copy-pasted across. And we've got the fraudulent email addresses that appeared at the very top of the email sending the payment requests. And what we say is that given the processes that the bank said it had in place and the sheer number of those red flags, and indeed the significance and seriousness of some of those red flags, that it stands to reason that a reasonably competent banker would, at the very least, we say, have been put on inquiry in suspecting fraud. And we would invite Your Honour to conclude that that's the only reasonable conclusion that can be drawn from any of this. We would also invite Your Honour to observe that this is not even something which unfortunately comes as a surprise, because we have evidence elsewhere that the bank's due diligence during this period in time has been audited and found to be wanting. And specifically, the bank had a poor track record in its due diligence. We've got the audit report, which I referred to during cross-examination. It's at E1294. And there were a number of relevant entries in that, but perhaps the most striking one was the observation about a high-risk area whereby pro forma invoices were collected, but bills of lading were not. And then that brings us on to breach, which, as I say, is a short point. It was perhaps in a way that is not necessarily being accepted, but is also not necessarily inaccurate. One aspect of the Quince Care duty is effectively that it's a negative duty. Once you're on inquiry, your duty is to not affect the transaction. And so breach becomes a pretty simple point at that stage. Once we are satisfied that the duty is engaged, what the bank ought to have done was not to have processed the transaction. And we say that it's, of course, undisputed that 2 of the transactions were processed. In this case, it follows, we say, in breach of the Quince Care duty. So that's our position on Quince Care. On the defences, the way I've addressed this is to look at the exclusion defence and the contributory negligence defence. So on exclusion, we say the defendant's analysis doesn't work, and there are a variety of different reasons for that. So on the letter of indemnity, first of all, it's not part of the facility agreement, so we say it doesn't apply. But in any event,
Well,
it's not.
Why do you say that?
I'm going to come on to that. I'm just going to explain how I set it out. But we say it's then not engaged, and the facility agreement, we make similar observations. So first of all, it's not engaged because it's not about payment instructions, but for other similar reasons I'll explore with the letter of indemnity, it's also just not engaged on its own terms. A point we make about both is that if the defendant is right about their interpretation, then we say that would infringe on the reasonableness requirements of the implied contract terms law. And the fourth point we make is that it's impermissible for the defendant to seek to limit its liability in some of the ways suggested under DFSA administered rules, and specifically that will attach to the Quince Care duty. So On the letter of indemnity first, the first point we make is a pretty short one, which is that it's not part of the facility agreement because we can see what the facility agreement comprises in its own express terms. So it's a page H.
Question really, is it? The question is whether it was part of the banker-customer, a term of the banker-customer relationship.
Well, no, because what we say on it
was.
Sorry, Your Honour, I didn't catch that last comment.
My recollection is that Mr. Agarwal agreed, in effect, that it was.
Well, I suppose first of all, it's not a question for a witness of fact. Whether or not it is a binding contract is different from whether it is a binding contract that is applicable to the use of the facility. So whilst the letter of indemnity might be a provision of the contract governing the usage of the current account, we say that it is not a provision governing the use of the facility.
It's an agreement that this will govern the current account which was then being opened and any other account that Aegis has with the bank. I think those were effectively its terms.
Yes,
Now,
that's what the letter.
After had another account, namely the TR account, the question is why did it not then spring into action and apply to the conduct of that account also?
Yes, well, the answer we give to that is because of the definition of agreement in the facility agreement. So it's a page H24, but what it says is agreement shall mean this facility agreement and all attachments and schedules appended hereto, and shall also include any subsequent written modifications and amendments thereto duly made in writing by the parties after the date of execution of this agreement. So what we have is a express term which is clearly telling us what the whole of the facility agreement is, and the letter of indemnity is not attached to that. If the parties had wanted to incorporate the letter of indemnity as part of the facility's terms of usage, the contract would have said so. That's the short point that we make on this.
Yes, I understand that. Thank you.
The second point is slightly longer, but it's one that we say is equally clear anyway, which is that it's not engaged because the letter of indemnity sets out its own scope in its opening paragraph. It says, we request the bank to accept instructions which may from time to time be or purport to be given to the bank orally in person by facsimile or by any other electronic communication acceptable to the bank on our behalf relating to the operation of all or any of my accounts. So 2 points in that really. First, electronic communication acceptable to the bank. The way one has to read that is that the letter of indemnity can't really be a freestanding document that operates in the way that the defendant says that it does, to suggest that there is an authorized email ID and the bank can act on instructions from that. And the reason for that is that, for starters, the letter of indemnity does not refer to any specific email address, nor does it refer to email at all. So there would have to be some form of communication or agreement as to what the bank does or does not consider to be an acceptable form of communication, and an express term governing that for this letter of indemnity to actually bite in the first place. So it's not simply saying...
It's a very strange document. There is a question in my mind whether on its proper construction it applies to anything but facts. I should make that plain.
Well, yes, Your Honour, and I think in my submission, one can derive that intention from the document. So if you bear with me, I'm just going to open it up. And I would actually make a similar point when I come on to clause 18, because I think there are provisions in there which lead one to that conclusion as well. But one can see, for example, when we get to the language of clause 5 of the indemnity, it says, we agree to bear all risks in relation to any discrepancies or errors in the figures or instructions or messages as a result of any malfunction of the facsimile machines or misunderstanding or lack of clarity of instructions. So, and you know, we can't ignore the fact that it says it on its own title, its application and indemnity for facsimile instructions. Part of this, I suppose, will in any event come back to some of the questions we're discussing on reasonableness under the implied terms law, but it seems to be on its face what this is getting at to prospective customers of the bank is dealing with fax instructions. That's what the substance of it appears to be predominantly aimed at. It doesn't actually refer to email in its body at all, and as you say, it's quite an unusual document. But we say that one can't just start with assuming that the intention here is that without more this extends to communications made orally, by facsimile, or by any electronic communication, full stop, because that effectively describes any form of communication, perhaps short of smoke signal, but that would suggest that the bank is entitled to act on an instruction it's receiving by text message, or an instruction it's receiving by WhatsApp or Morse code, or whatever way you want to look at it. It's too broad to be read sensibly in that way, which is why I stress the relevance of this this caveat that's added in the express terms, which is that it is a form acceptable to the bank. And so what we say is that the form that is acceptable to the bank was in accordance with the established payment process between the claimant and the defendant, which was followed for the purposes of the facility agreement. The second point, again, I think we say is an obvious point, but it has to also be a communication which relates to the operation of an account or facility on its any face. So we can see that it refers to being bound by the terms of this application and indemnity with respect to such instructions. So what we say about that is that it can't get the bank anywhere when it comes to the breach of mandate case, because the communications, whatever way you look at it there, are not communications in relation to the operation of an account. They are communications which fall outside of the express operation of the facility.
I don't follow that. Why not? Is your reason for that simply because they were communications from the fraudster rather than Aegis? Is that your reason?
It's 2 points. It's communications from the unauthorized party, but it's also because it's not a communication that purported on its face to seek a valid drawdown of the facility, because it's not within the permitted scope of the facility.
Well, okay, but it did seek a drawdown from the facility. Why isn't that relating to its operation? The answer to the communication might have been no, because it's not within the facility, but it related to the operation.
Well, I think we would disagree that it did relate to the operations. The facility was there to provide a specific service from the bank that had defined parameters. If an even more extreme example was someone requesting a drawdown to pay for their house, we would say that that couldn't possibly be a communication which is in accordance with the operation of a facility, which is to deal with the supply of raw materials.
I must say I have difficulty with this, but I understand what you say.
Yes, and Your Honour, I think probably before, well, I suppose this is coming slightly back to the point I was making about this not being part of the facility agreement, this document not being part of the facility agreement itself, is that on the defendant's analysis, they say that there are specific provisions dealing with this. And if that was the case, one would expect the expressive agreement of the parties that it is to be governed by a specific set of documents, which do not include the facility, would be consistent with this document being of no application when it comes to the facility. The third point we make is to say that in any event, this type of indemnity is not sufficient to exclude the Queen's Care duty. And this was an issue that was discussed at some length in the Nigeria and JP Morgan case that I'd referred to in my skeleton and I've referred to in the outline. And that was the case.
I just understand where you're going because it may help. Is this the proposition along the lines that if you're going to exclude negligence, you have to do so clearly?
Yes.
Right. I understand where you're going. Yeah, please continue with it by all means. But
yes. And for that matter, not simply negligence. If you're going to exclude any contractual right, express or implied, we would say this. We would make the same point. But a helpful starting point might be if Your Honour goes to Bundle G, page 418. There'll be tab 2. This is the first instance judgment of Professor Burrows, QC.
Again, I have managed to be logged out, so...
Dear.
Yes, I'm there.
Thank you, Your Honour. This is setting out some of the examples of the indemnities and exclusion clauses that were relied on in that case. And I only highlight them because they're instructive to the extent that some of them are quite similar to what we see in this case. So, for example, you see 7.2, the depository should be under no duty to inquire or to investigate the validity, accuracy, or content of any instruction or communication. 7.4, depository need not act upon instructions reasonably believed to be contrary to law. 8.2d, should not be liable to the depositor for any loss suffered by acting on what it in good faith believes to be instructions or in relation to notices, waivers, and so on, to be genuine and to have been given and signed by the appropriate parties. A broader indemnity at clause 10.1 in respect of following the instructions of or directions upon which the indemnities is authorised to act or rely pursuant to the terms of this agreement. So effectively the point of raising that is just to say that we're looking at something which treads on similar issues to arise in this case. And if we move forward to this judgment at page 423, I've said 423. I think that might be wrong. Bear with me, see if I can find this.
I think it's further on.
Paragraph 34, 3, which is at 428.
Yes.
So this is a statement of what the law says about construing these sorts of provisions. So it's applying the modern approach. The force of what the contra proferentum rule is embraced by recognizing that a party is unlikely to have agreed to give up a valuable right that it would otherwise have without clear words. And it refers to Lord Justice Morbeck in the Stotsnia case, which is the more valuable the right, the clearer the language will need to be. So it's not a particularly controversial statement of law. The point is that where one is seeking to exclude or indemnify itself from the valuable right that another party would have, including the Quinscare duty, clear words are required. If I can take Your Honour on to paragraphs 46 to 48, which is at page 432.
Yep.
We see how that analysis can work in this sort of context. So this is the clauses 7.2 and 7.4. The depository shall be under no duty to inquire into or investigate the validity, accuracy, or content of an instruction, and the depository need not act in instructions it believes contrary to the law. And what the judge says there is that these clauses are consistent with the Quinscare duty and what the Quinscare duty requires, which is it imposes a negative duty not to pay despite compliant instructions where the bank has reasonable grounds for believing that it would defraud the customer. He's explained that in line with what's been said in those cases, I'm strongly inclined to the view that once the bank has those reasonable grounds for belief, and this is a discussion in that case about whether or not the Quinscare duty is actually extended a little bit further than some had thought, and imposes an additional duty to make reasonable inquiries to satisfy oneself of a position. Nothing turns on that in this case. But what he then says at 48 is that the correct interpretation of clauses 7.2 and 7.4 is that apart from the opening sentence in 7.4, which is plainly consistent with the Quinscare duty of care, they do not apply at all where the bank has reasonable grounds for believing that the customer is being defrauded. So the way the judge...
We're not concerned with that sort of clause. We're more concerned with the kind of clause that is in paragraph 53, aren't we?
Well, the point I was going to make about this set of clauses is that we also see something similar, not only in clause 18, but in the letter of indemnity, where we find provisions that are plainly consistent with the Quinscare duty. So if one looks at clauses 3, 4, and 8 of the letter of indemnity, those are provisions which entitle the bank, they say, to stop an instruction from being processed at its discretion in a way that we say is not only consistent with the Quinscare duty, but actually seems to anticipate it. Yeah. So the proper reading of that rule. Your Honour, do you mind if I pause for 1 second so I can shut my window? I think it's
yep. Yes.
Beg your pardon, Your Honour. I've had to switch off my camera to spare you the graceless reaching over my computer that I have to do to get to my window. So yes, the point there really is that some of these clauses that we find in the letter of indemnity anticipates the fact that there may be reasons why the bank would need to, in some circumstances, prevent a payment from being effected. And if we come on, I think it's over on page 433. We find discussion on clause 8.2d, which is depository shall not be liable for any loss suffered acting on what it in good faith believes to be instructions in relation to notices. And there's some insightful analysis we say there in relation to where, if you have the bank being on notice of fraud, it can never be consistent with a duty that the bank would have in good faith for it to nevertheless decide to proceed with the transaction. And this aspect of the judgment was effectively given the stamp of approval by the Court of Appeal. Let me refer your Honour to one paragraph of that, paragraph 40, which is at G455.
Yes, I'm there.
And this is the broader statement of principle that arises from the analysis set out in the first instance judgment, which is applying the principles, in that case, as reference principles construction in the present appeal. The Quince care duty is one aspect of the bank's overall duty to exercise reasonable skill and care in the service it provided. It can properly be described as one of the incidents in which the law ordinarily attaches to the relationship between the bank and client, and it is a duty which is inherent in the relationship. It is not therefore negated by the existence of a clause which narrows down the obligations of the bank to the basic obligation of holding the money and executing instructions received, because the obligation to perform those functions with reasonable skill and care is part and parcel of the basic obligation.
Yep.
So what we have in the letter of indemnity, and in clause 18, if you accept the defendant's analysis that it's engaged, which I'll come on to, what we would have are provisions which relate to how the bank goes about executing its instructions. The point that we derive from these cases is to say that the duty to exercise skill and care is inherent in the way that those agreements work. So because we're talking about executing instructions, and it is inherently, we would say, obvious that the bank has to exercise reasonable skill and care, the provisions are not engaged when there has been a breach of the Quince care duty. So as Professor Burrows put it in the first instance judgment, that the provisions will not apply at all where the bank has reasonable grounds for believing that the customer is being defrauded, because it's an inherent part of their duty, whichever way you look at it. And I think that the view has been expressed by some is that whilst it may not yet be impossible to exclude the bank's liability for breaching the Quince care duty, were that to be the case, you would need very clear words saying that, and those simply just don't exist here. And following the JP Morgan analysis, we say the Quince care duty cannot be displaced in this case.
Right. Now we've been going for a couple of hours. How much longer do you think, Mr. Doherty? And I should add that your outline doesn't refer to it, but I do want to ask you something about the kind of relief you are asking for, the amount of money you're talking about and where the evidence in support of that is. How much longer, therefore, do you think you'll be?
Your Honour, I have it's not too long in the substance of those part of the submissions. I'm happy to take a break. I think probably 15 minutes.
I think we will take the break now, but you may have been going to do this anyway, but I do want to ask you just what precise relief do you want, because it's been a bit left up in the air, and I'm not familiar with the documents or other evidence that show just what has happened about repayment of the bank or the bank demanding payment or whatever, which may go towards the nature of the relief that you claim. So in the 15 minutes break, please, would you see what you can do to anticipate my questions?
Certainly, Your Honour.
Right, 15 minutes, gentlemen.
Thank you. Thank you, Your Honour.
Right. Okay, please continue.
Your Honour, the final point for now on the letter of indemnity were our submissions on Articles 37 and 38 of the implied terms law. In short, our submission is that were the letter of indemnity to be given the interpretation contended for by the claimant, that would not be reasonable, and there are a number of reasons for that. There's the obvious point, which is the one that's set out in Schedule 2 to the law, regarding the obvious gulf in bargaining positions between a bank and a small business as to the terms in which the parties operate. But the more specific points relate to the breadth of what is being suggested the letter of indemnity covers. The position that it, I think, sets out in my learned friend's case is effectively we have an indemnity that will apply to all past and future agreements that may be entered into. It's stated to be for an unlimited period of time, and it's given a broad interpretation that seems to exclude liability not only for all claims, but effectively for any instruction which has been given by most conceivable ways of communication. So, as I say, it's orally, in any form of writing or any form of electronic communication on that analysis. And we say that for an exclusion clause purport to be in such broad terms is not reasonable. And we also draw, I think, assistance from some of the observations that were made in JP Morgan regarding this. So it's at page 430 of bundle G. And this is the first instance judgment, and I'm looking at paragraph 44.2 specifically. And what the judge says there is, if one were to interpret the reference to express terms of the contract as ruling out a quince care duty of care, and this is in relation to the operation of clause 5.1 of the agreement in that case, all other manifestations of a bank's implied duty of care to a customer in respect of the depository cash and all other liabilities imposed in tort or in equity, including, for example, the tort of deceit or knowing receipt or dishonest assistance or breach of confidence, be excluded. And it's the last comment that we draw on in particular, which is that would be an alarming interpretation, given it would deprive the customer of many valuable rights. And we would make the same observation here, which is that a term which would purport to deprive the customer Aegis of effectively any and all rights is alarming and on its face is not reasonable. Your Honour, that's that point. I want to come on to clause 18 of the facility agreement, which is page H68. Some of the arguments trespassing points I've already made, which I'll deal with shortly, and there are some new points in relation to this as well. The first is that we say that the defendant has misunderstood the purpose of this clause. We say that this is something which commonly appears in many standard form contracts, and what it's getting at is how you provide formal notices pursuant to the terms of a contract. And the example given during evidence when it was put to a witness is the example we find in this contract at H64 and clause 14.2, which deals with events of default and termination. And that's typically the sorts of circumstances in which these notice provisions often arise. So when a party needs to give notice that it is terminating an agreement to another party, it will give that notice in a prescribed form, which is set out in the contract. And that's what we say clause 18.2 deals with. And we say that that is also consistent with how the parties went about their business and practice here, because neither party had considered that this had anything to do with payment instructions. And the reason we know that is because, first of all, clause 18.2 is not, it's not a one-way street, as it were. Your Honour, if you're looking for the references, page 868.
I have it.
It's not a one-way street. Clause 18.2 has an A and a B. So if on the defendant's analysis there is what they've termed as the authorised email ID from which it was entitled to accept instructions, the flip side of that is also true, which is that the bank had an authorised email ID from which it was to send and receive communications. And it's set out there as difc.dubai at unionbankofindia.com. There's no evidence anywhere of the parties having sought to avail themselves of notifying the lender not less than 5 days for a change in address. Were such a notice to be given, it would have had to have been given by difc.dubai at unionbankofindia.com to admin at aegisoverseas.com. But it's simply not there. And so when we apply that to the facts of this case, what we see is that the fraudulent payment requests were, on the defendant's analysis, sent from what it calls the authorised email ID, but they were not sent to the authorised bank email ID. And as such, on that analysis, they could not have been proper instructions under clause 18. And on that analysis, we say that that in itself would have been a red flag, because if the parties had agreed that this was their mechanism for instructing payment requests, the very fact that one was received outside of those express terms should have led the bank to say, this is not a valid instruction and we're not going to act on it.
I should say, Mr. Doherty, that my present view is that 18.2a really has nothing to do with this case, because it is concerned only with communications to Aegis. It has nothing to do with communications from Aegis.
Yes, Your Honour, and that's the point we'd make about clause 18.1 in particular as well, which seems to make that clear. But Your Honour is right. The first level of the analysis is just that we're not talking about the same thing here. This is, as I say, a provision for contractual notices, it doesn't seem to be engaged in its operation in this case. But even if one were to go a step further and to accept the premise of the defendant's analysis, that this was how communications were supposed to take place, it would suggest that any communicated instruction coming from Aegis would have to go to a particular email address for the bank, which it didn't. I'm sorry, Honor, did that, in a roundabout way, come close to answering the question, the point that you'd raised?
It has nothing to do with the point that I raised. The point that I raised is one which Mr. Duckworth will need to deal with.
Yes, Your Honour. I think the broader point I would make is that there are layers of different reasons why this provision does not assist the defendant, certainly not in the way it says it does. The next point that we make is on scope, which I've already addressed, Your Honour, on. This is similar to the letter of indemnity in that it is in relation to something which is in connection with the agreement. And I've already made the corresponding point on that with the letter of indemnity and the operation of the agreement. So I don't think I need to repeat that submission. We've also got the JP Morgan point, again, which is if one were to try and exclude the operation of the Quince care duty, you would need there to be clear words or clear inconsistencies in the operation of the clauses, and that, again, doesn't assist here. And it's also worth pointing out, I think, that on the same point that you need clear terms to exclude liability. This comes back to the issue about what we're really dealing with here. If we look at clause 18.6, it's discussing circumstances in which the lender shall have no liability, and the express wording of 18.6 limits that to circumstances on which there is a fax which includes a cover sheet or at the head of the first page thereof a reference to the name of any other party and is signed by a person who is so authorised in a board resolution. Now, given the contra proferens rule, the bank has to be held to the strict wording of that, which suggests that this is a clause relating to something that has to be received by fax. And we say it can't get outside the express wording on that. And we make the same points again regarding unfair terms as we do in respect to the letter of indemnity if this were to be given the interpretation contended for by the defendant. And another layer on top of that is the observation I've referred, Your Honour, to on good faith, which is the issue flagged in the JP Morgan case. And we can see it clause 18.7 here, the lender should be entitled to act in accordance with any fax and message, provided that it is acted in good faith. And my submission on that would be that if a bank is on inquiry of a potential fraud and it nevertheless decides to effect a payment request, it cannot be acting in good faith. And then the final point, which is a broader point which applies to both purported indemnities, is the restrictions on a authorised firm's ability to limit its liability under the operation of DFSA rules. As I said at the outset of my submissions on the Quince care duty, effectively it is another statement which corresponds to duties that the defendant owes as a matter of regulatory law in the DIFC and under the DFSA's administered laws, which is it has to act with due care, skill and competence. So that's General Module 4.2.2 which Your Honour would find at G439. And the point we make here is that in the conduct of business sourcebook for the DFSA at Rule 3.2.2, there is a provision that says that an authorised firm must not, in any form of communication with a person, including an agreement, attempt to limit or avoid any duty or liability it may have to that person or any other person under legislation administered by the DFSA. So there we have the DFSA's rule saying that you cannot exclude your liability for failing to act with due skill, care and diligence. And that feeds, I think, into the point that's being made in JP Morgan, which is this is an inherent duty of the bank. And when it comes to its execution of instructions, it is so inherent that it's not one that, absent very, very clear words, can be excluded by the clauses that we have here. And so we say that the DFSA rules say the same thing on that. Your Honour, those are my submissions on the indemnity clauses. If you're content with that, I'll move on to very briefly what we say about contributory negligence.
Yes, thank you.
Respectfully, we say that this aspect of the defendant's case is a non-starter. In response to the defendant's own question and examination in chief as to what a company who has no expertise in IT should do to protect itself, Mr. Amin's answer to that was that they should hire somebody to apply security features. And that's precisely what happened in February 2019, so 3 months before 4 months before the incidents in this case. Aegis have gone, they've sought expert advice, they've instructed an IT firm who specialise in cybersecurity, FutureX, to provide them proposals for what their needs were as a business, which we can find in the bundle, Your Honour, at page E491, and we explored it with Mr. Amin during evidence yesterday. But in pretty short order, what was recommended was that Aegis should get Symantec endpoint protection, that they should implement Microsoft 365, and that they should adopt managed services for those so that the people responsible for running them and adapting the settings and configuring the system were IT specialists. And that's precisely what Aegis got. They got Symantec, they got access to managed firewalls, and managed Microsoft 365, which means that FutureX were setting up and managing all of the mailbox settings associated with Outlook and all of the security features associated with Microsoft 365 and also with Symantec. Now, what we would say is that's enough. It's we would say self-evident in the modern commercial world that hacking and phishing are unfortunately facts of life, and we heard Mr. Saman's evidence on that, which, as well as being quite interesting from a layperson's perspective, was pretty clear, which is that this does happen, and it does happen all the time. What we say are the residual criticisms of the defendant about the claimant's actions are slightly misplaced. One of the criticisms is that Mr. Agarwal would have received a notification and acted on it. It seems to me, Your Honour, that that's a simple question of fact. Mr. Agarwal was asked the question, did he receive a notification? And he said he didn't. And we've heard evidence from Mr. Saman that in business accounts like this, you wouldn't get individual user notifications and that those would go to a dashboard, which is managed by the IT specialists, who in this case are FutureX. What the defendant also does, we say, is to try and apply a standard of security that was simply not in place at the time. So we're potentially trying to apply modern standards to what was in place 2 years ago. And as I suggested to Mr. Amin, and he accepted, this is a fast-moving area. What the literature that Mr. Saman has referred to showed is that the implementation of two-factor or multi-factor authentication, whilst available and best practice, was prior to September 2020, so we're looking at over a year after events, only implemented by 9% of users on Microsoft's own literature, and wasn't set up as a default setting in Microsoft's own products until October 2019, so after the event. But beyond any of that, what the company does in this field is entirely reliant on the advice that they have been given by experts that they have instructed and trusted to give them sound advice. A proposal was put to Aegis and it was accepted and implemented in full. And it's difficult to conceive what more a business could do in those circumstances. So Aegis was reliant on its IT consultants to advise them on these issues, and it was reasonable for Aegis to accept that advice. And really, that's all we have to say about contributory negligence. We say it doesn't get the defendant everywhere. We believe that the claimant has acted entirely reasonably. Your Honour, unless you have any questions, that's what I have to say about the substance of the case. As a short note on relief, as you alluded to, part of the, I suppose, confusion surrounding relief has been over an issue as to whether or not the bank had been treating this as a first-party law, so its own law, so whether it was being treated as Aegis laws. It seems as though we've now resolved that it's the former, which is why we have the particulars of claim having been amended in the way that it was. So the situation now, well, I suppose going through it slightly step by step, the initial mechanism of the transaction was that sums were paid from the TR account into the current account and then out to the fraudster. And what that then shows as is a debit in the TR account. There had been some change in this as time has gone on, because unconnected to the fraudulent payment requests, at one point in time, the claimant had paid in $1.5 million into its current account, which was then applied in part to the fraudulent payment requests, though I understand that that position has now been reversed. So as it currently stands, the sums, so that's the 826,000 and the 241.5 thousand are shown or are reflected in the claimant's TR account as a debit.
Which still is open. In other words, it has not been closed by payment by Aegis.
Correct. That hasn't been paid.
So the bank. So are we at the situation where the bank is saying we have advanced to you under the TR account a total amount of, let us assume, $10 million. Part of that is the $1 million that we're concerned with, and the bank says we want repayment of 10 million, whereas Aegis says we only owe you 9 million. Is that where we're at?
Yes, that's effectively the position. There's been
not a to Mr. Duckworth.
No, the position is that the claimant has repaid its facility with the exception of these two amounts.
Okay, so the bank is saying, however, you have to pay us another $1 million. We want you to pay another $1 million. So the question for me in the end is, does he just have to pay the $1 million? And that will be answered by, because there's no counterclaim, no cross-claim by the bank, that will be answered by a declaration one way or the other, by me saying Aegis must pay the bank or Aegis does not have to pay the bank. Is that where we're at?
Well, I think that's where we're at, Your Honour. I think a further possibility is that you say has to pay X to the bank. If you made a finding of contributory negligence, for example, you might apportion portion of the amount. That's obvious.
Whatever the amount is, let's assume there's some discount for contributory negligence.
Yes.
Right.
Yes.
I understand. Okay. Well, if we have a agreement that the form of relief will be as a declaration as to Aegis's liability to the bank, then I can proceed accordingly.
Yes, Your Honour. And then on top of that, you may have noted from the particulars of claim, there are claims for consequentials, which are explained in Mr. Agarwal's statement. So
I do not have that in my mind at all. I know.
Shall I give explanation?
Yeah.
Just because it may assist. So effectively, there are three. So before I come on to that, I should clarify, Your Honour, it's not quite as simple as the total sums of the two fraudulent payment requests. There was about $4,500 which were recovered by Singapore police, so that will need to be factored into the amount. So I just wanted to clarify that.
I recollect that, and thank you for reminding me.
So the consequential losses claimed are bank charges for a small sum, I think it's $60. We've got a claim for loss of utilisation of that portion of the facility. So we had a facility for 10 million, of which the company was only able to access 9 million, and it's claiming what it says is a 3% profit margin that it would have made had it been able to access those sums. And then there are claims for management fees, which are explained in Mr. Agarwal's statement, which are effectively his management time in having to deal with this issue, which is calculated by reference to his salary, effectively.
Can you, number one, can you give me some references to where I find that evidence? Number two, is this a matter of dispute because it hasn't received a single word in the course of the evidence? If Mr. Agarwal has said this happened and therefore I claim X dollars and it hasn't been cross-examined, then it looks to me as if the bank agrees. So what is the story?
Yes, Your Honour, I suppose it's a matter of
Mr. It is viable, I should say, if there is a breach of duty.
Yes, Your Honour. I suppose that's a matter for my learned friend's submissions. I would agree with Your Honour that that's the position we're in. The references, I'll give you a few. So the reference for the sums for the Singaporean police is at C24, which is paragraph 124 of Mr. Agarwal's first statement. The calculation for loss of utilisation of the facility for trading purposes can be found as a schedule in the pleadings bundle at A224. And the evidence in relation to management fees.
Well, hang on. The schedule in the pleading, that's only a pleading. Is there any evidence?
Sorry, let me find you the reference in the. Let me give you the other reference to the management fees evidence first, which is C24, paragraph 1, 2, 3.
Huh?
And Your Honour, what I would maybe suggest is I'll dig out the information in relation to the other consequential loss, and I can provide that to you as a bundle reference once I find it. But I can do that at the end of Mr. Duckworth's submissions, perhaps.
No, I'd like to take the time to do it now because it's something Mr. Duckworth will have to deal with.
Bear with me, I'm just going through the witness evidence to find. Your Honour, I have to give my apologies. I'm struggling to find the page reference. Perhaps we can proceed in a way where my instructing solicitor is obviously listening in, and we'll be able to send the page reference as soon as I've got it, and far before the end of Mr. Duckworth's submissions, we can provide it so that can be addressed. Would that work?
Yes, all right then. Thank you, Mr. Doherty. And Mr. Duckworth, in the same way that I do not have in mind any evidence on those subjects from Mr. Doherty's side, I do not have in mind anything that your side may have by way of evidence either. So if there is something, I'll need to ask you to refer me to that. Otherwise, the position is that there seems to be uncontested evidence from Mr. Doherty's side, so you'll have to deal with that.
Yes, so perhaps that's my fault, Your Honour, but I was under the impression that no evidence had been led on this topic. It looks as though I may have overlooked part of a statement, which is regrettable.
Anyway, well, let's park that for the moment. Mr. Doherty,
Yes.
He's provided two references, paragraphs 123 and 124 of Mr. Aegis' statement, and he's going to provide more, which presumably is somewhere near that. So park that and please embark on your submissions otherwise.
Thank you.
I have received your outline, thank you very much, of closing submissions. I have done no more than glance through it. I'm afraid I didn't have time in the break anymore.
Our submission is that, primary submission is that the relationship between the bank and the customer here is determined by the law of contract. And therefore the key documents are the various contracts the parties entered into. But I picked up on something I mentioned in the Corseman and Friend submissions, which is that here was a banking relationship. Not everything is determined by a particular piece of paper at a particular time. There are, outside of the paper contracts, there are also practices that obtain, indeed, that have been relied on by the claimant in the way it's attacked the witness evidence of the defendant. So it's important to set this in context and see it in the context of a developing relationship. I'd like to pick it up from the beginning, if I may, in bundle H, and just look at the various stages of the development of the relationship.
We have been through this quite a few times in the course of the evidence. Can you summarise, and if I am in doubt, I'll ask you to take me to documents.
Yes, well, I needn't refer you to the action document. The beginning of the relationship in November 2016 was, as you may recall, a $5 million credit line in a document which included conditions, precedents, stipulations, undertakings, covenants, and requirements to disclose all information, much as you would expect with any facility. Document signed by Mr. Agarwal as the authorised signatory, and ever since then his signature has been the key to any transaction. On the 9th of February 2017, there's an important watershed because the company applied to open a current account, number 57, with an initial deposit of $10,000. And in that account opening form, it gave its first description of its principal trading activities and geographies, And we make the point that in the course of a banking relationship, it's highly likely that both the trading activities and the geographies will develop over time. After all, the object of giving a facility to a young company is to help it to grow, and as it does so, it's likely to diversify. Again, Mr. Agarwal was the sole signatory, and his signature was witnessed by the bank reference page H8. And it was recorded that the Aegis Resources Company had approved the arrangements by a board resolution, reference H10, paragraph 3. Mr. Agarwal gave due proof of his identity at H14. And it was on that occasion, the opening of the current account, that the company entered into the indemnity letter. And I pick up your point, Your Honour, about whether that was limited in some way to simply to fax instructions. Perhaps I can take you to that page and we can discuss that. It's page H15.
I have it.
First point I make in passing is that the account number CD/TR, well, that's not an account number as such, but it seems to incorporate a reference to a TR account, which was then in existence in the smaller sum of $5 million. It goes on that we hereby request the bank to accept instructions which may from time to time be or purport to be given to the bank orally, in person, by facsimile, or by any other electronic communication acceptable to the bank. Now, Mr. Doherty makes the point that we say is not a good one. He says that there has to be some formal acceptance by the bank of the use of some other form of electronic communication. And we say that's simply not right. The use of electronic communication could be of a variety of kinds, but obviously what's principally envisaged here is email. And as we know, the practice developed of using email frequently and regularly, as one would expect with a business of this size. And so was the bank capable of accepting instructions by email? This letter says yes, in relation to the current account. Now, the other obligations also arose from this letter. First of all, the bank wasn't obliged to identify the party giving instructions, but it could, at its discretion, require additional identification. And it wasn't obliged to inquire into the purpose of any transfer authorized by such instruction. And if the bank was unable to execute a transaction, paragraph 3, then it wasn't liable. And so it continues. At 5, we have the important paragraph about risk. And we make the point that in a banking relationship like this, it's entirely open to the parties by contract to contract out of risk or to allocate risk from one party to the other. That was done, and that was understood to be the position at the beginning when the account was opened. Your Honour asked whether this communication was limited to facsimile alone. It's true that the heading is facsimile, but in the body of the document it says or any other electronic communications, and so we say that it had a wide application. That's what I say on that. Then shortly after this, 3 months after this, the company applied an increased facility of $10 million. That's H18. And you will recall that Mr. Agarwal, in his witness statement, his first witness statement, says that he was responsible for sourcing and developing relationships with mine owners. Clearly, there was some growth in the business, and consequent on that, one would expect from time to time new customers to be added to the list of existing customers. And it would not be a surprise, therefore, for the bank to see invoices from one or more new suppliers. Nor for that matter would it be unusual to see the company spreading into new geographies, because at an early stage a company has obviously a restricted reach. As it grows and as it expands, its reach extends. The material terms of the facility were unchanged. And then a fuller facility agreement came into being on the 29th of June 2017, which was a new template. And this was a fully drafted contract incorporating all sorts of things you would expect to see in a proper loan facility, including conditions, precedents, covenants, representations, undertakings, definitions of events of default, and notices. And there was also new provisions about how the TR facility would operate. Now, I need to deal with the interpretation of paragraph 18 of this letter. So if I may go to the facility agreement. And the page comes up.
Can I just stop you for a moment? You've made the point that one could expect the business to grow and to get new customers and perhaps deal in other ways than originally.
Yes.
But this facility agreement, have not the parties agreed to freeze the business that it's carrying on?
No, that would be
Not
that
to
would be very unlikely.
not carry on any other business, but for the purposes of their agreement, the nature of the business is frozen. That's clause 4.2.
Your Honour, we don't, with respect, accept that interpretation. But let me look at 4.2 and deal with it.
It's not just 4.2, it's also the provision, which I cannot remember now, about use of the facility only for the purposes of JSW.
Yes. (4.2) said that any advance shall be used for imports local purchase under letters of credit and so on. There are a number of covenants there. We make the point, Your Honour, that in general, the covenants under an agreement like this are made by the borrower in favour of the lender. It's not a restriction on the lender's ability to advance funds for any purpose. It's a restriction on the borrower's ability to misapply funds, as it were, into new ventures that haven't been approved. There may be a number of reasons for that. One might be regulatory. For example, it's necessary for the bank to know and have a handle on which companies are being supplied to and in which countries for the obvious reasons. But it wouldn't be right to say this was a straitjacket on the way the bank could lend, as if, and indeed as Mr. Doty puts it, effectively, the company would be acting ultra vires, or the bank would be acting ultra vires if it lent money for some other purpose. That's not the way loan agreements work. By and large, all of the covenants in a loan agreement are for the benefit of the lender, for the obvious reason that where the lender is advancing substantial funds, it's the one at risk. And so it's entitled to request detailed covenants, indemnities, assurances, representations, and so on. It was entirely open to the claimant to decline to enter into these terms, but because it wanted the facility, it was prepared to do so. That's the way we look at this agreement. So with respect, we don't accept that there was a limitation on the kind of goods that could be purchased or the purposes to which the funds could be put. Just a way of enabling the bank to monitor the progress of the facility. Coming to clause 18, I would accept Mr. Doty's point that in the first instance, this clause is talking about contractual notices, because obviously you would expect to find a notice provision inside any commercial contract like this. But the scope of the text of the paragraph, however, expands beyond So whilst the section is headed notices at page H68, it goes on to say in 18.1, any communication to the borrower to be made under or in connection with this agreement shall be in writing, and unless otherwise stated, be made by fax, letter, or email. By definition, any communication is wider than simple notices. 18.2 then gives what we would submit as a starting address for each party, which could be changed by mutual consent as time went along. And in practice, what happened here was that DIFC Dubai fell largely into disuse, and instead the communications were with the operations department. Does that mean that the parties were acting outside the facility? That's unthinkable. They simply substituted a new address by custom and practice, and that became the accepted substitute. That is well within, we say, the intention of clause 18.2, that any communication made or delivered in connection with this agreement shall be given to the addresses below or any substituted address as the parties may notify.
How in your case does the address in 18.2a matter? It seemed to matter quite a bit in the course of the cross-examination, so let's try and see why it does matter.
Well, 18.2 begins the address, fax number, and telex number of each party for any communication or document made or delivered in connection with this agreement. Is that identified with its name below? So, to start with, the admin at Aegis-overseas.com was the address for delivery of any communication relating to the facility agreement. That wasn't limited in our submission to formal notices, but also included routine emails.
Yes, well, now answer my question, please.
What, could you repeat the question?
I'll amplify it a little. My understanding of the cross-examination was that it was sought to establish the proposition that an email from Aegis had to come from the email address in 18.2a. Is that the proposition that you were seeking to establish or not?
No, not any email, because emails might come from sales or sourcing to the bank.
All right. Well, what is the relevance then of 18.2a in your case?
It's 18.2a is not singularly relevant to our case. There was a mandate, and by the mandate, the authorized ID was admin at Aegis-overseas.com. We saw that with the current account, and
authorized for what?
For instructions to the bank.
Well, 18.2a does not say that. If anything is authorized, it's an agreement. Instructions from that communications from the bank shall be sent to that, may or shall be sent to that email. That's all. I just do not understand, I'm afraid to say, the emphasis that seemed to be placed on this in the course of cross-examination. I'm hoping you'll explain it.
Yes. Well, I'm just looking at it very closely again, and I read that the address of each party for any communication to be made or delivered under or in connection with this agreement is that identified with its name below. So any communication in relation to this agreement is not routine exchanges between company and the bank, for everyday matters, but either formal notices in connection with the contract or else payment instructions which had to come from the authorized email ID. The source of that authority is not necessarily this contract, but the earlier opening account document with the current account, where the authorized signature was that of Mr. Agarwal and remained so. So this.
Well, are you saying that a payment instruction did not have to come from the email address in 18.2a?
It could come from another department, but it had to be authenticated by the authorized signatory. There only ever was one authorized signatory on this account.
Okay, so it's the signature that matters, not the email address that it comes from.
Yes.
All right, well, let us proceed on that basis.
Yes. Now, 18.6 is relied on by the bank, and although it's attacked by Mr. Doherty as being irrelevant to the purposes that we're discussing in this case, it in practice was relied on by the bank because of what it says here, that the lender is to be under no liability in respect of loss suffered by reason of the lender acting in accordance with any request or instruction set out in an email or fax appearing on its face to be sent by the other party hereto, and so on. The person who could sign that kind of instruction was only the person authorized in a board resolution, a copy of which had been delivered to the lender. I've already mentioned.
Hang on. Let's just look at this. The person is so authorized. What does so authorized mean?
Well, that means that a board resolution is passed saying we hereby authorize Mr. Girish Agarwal to sign the bank account on behalf of the company. It can only mean that. We know that a board resolution was delivered with the payment instruction.
Yes, thank you. Right.
And then there comes the indemnity. Of course, the indemnity in 18.7 would make no sense if this clause is confined to giving formal notices under a contract. There'd be absolutely no need to indemnify the lender in those circumstances. Indemnity is required for payment instructions that, for whatever reason, go wrong. And I draw attention again to the expression in 18.6 that an email or fax sent to it or appearing on its face to be sent to it by any other party hereto. That was necessary for the bank's protection, and it requested it in more or less the same forms it had in the indemnity letter, that what appear to be instructions aren't always genuine, but the bank may be misled by that and make payments accordingly. And so an indemnity is necessary to protect the bank for what appears to be a valid transaction.
What about the apparent inconsistency that 18.6 refers to request or instruction set out in an email or fax sent to it, and then goes on to say if the fax includes something or other, but does not say anything about the email? How does one make sense of that?
Well, in my respect, submission, the answer to that is that you try to give it commercial sense. You don't strike out the paragraph as being too confusing.
What is the commercial sense?
Well, the commercial sense is either that the fax includes a cover sheet that's signed by the person, or else the email is signed by the person authorized by the board resolution. Otherwise, the clause doesn't make sense. It clearly applies to both email and fax, and it would be highly likely, that the bank could protect itself for any email purporting to come from the company, even if not signed by the authorised signatory. The obvious intention of the clause is that the signature of the person authorised is applicable to all cardinal transactions involving that might result in loss.
Yes, thank you.
Yeah. Then we have the renewal of the facility on the 27th of June 2018 with the extension of the wording to incorporate for the supply of any goods and services for manufacturing of steel to JSW Steel Limited. It's desirable, again, Your Honour, to give that expression commercial meaning if one can, otherwise it's simply surplusage. Now, we know that all supplies were in fact to JSW Steel. That was the company's only customer. So that in itself is not saying anything new, but the supply of goods and services, it envisages an expansion of the company's trade from goods alone to goods and services. And that is how the bank understood it and interpreted it when it came to the critical time in May and June of 2019. A lot of time was taken cross-examining the bank's witnesses about why the particular payment requests, the fraudulent payment requests, were passed when they didn't attach documents of title like bills of lading, or they referred to mining operations or other extraneous purposes. Our answer to that is that there are two things covered under what is now the established practice and facility between the bank and the customer. First of all, that the purpose of the payment may extend to services as well as goods. And secondly, paragraph 4.2 of the facility letter, page H37, it includes the procurement of goods. And it includes advance payment against pro forma invoices for the purchase of goods. Same reference. So, Your Honour, we have three distinct activities there, which represent an expansion of the company's original portfolio of activities, and it is the events of May and June 2019 have to be seen against that context. That is how they were seen and understood by the bank. And, Your Honour, as it were, in support of the commercial good sense of the arrangements that had been devised by the parties, I think we're entitled to point out that until the 30th of May, these arrangements had worked perfectly well for both sides. The borough had no cause of complaint, and all its instructions were duly executed. I then move on to findings of fact that we would seek in the light of the evidence given in this case. This is page 5 of my note. And these are largely self-explanatory. You can see them set out here. I don't think I need to amplify many of them.
Peter, I think the judge may have, I don't know if it's the same for you, the judge has disappeared from my feed.
Oh, no, he's on my feed.
Ah, my issue then. Sorry to interrupt.
All right.
You're back now, Your Honour.
Yes.
So just running very quickly through them, the relationship was two commercial parties acting at arm's length. There's no issue of consumer protection here. And as such, they were at liberty to negotiate whatever terms they pleased and to allocate risk however they pleased. And one looks at all of the written contracts together, which together form the contractual relationship. We would seek Your Honour's formal finding to the effect of subparagraph 6 here, that an unknown hacker penetrated Mr. Agarwal's email account. This is all common ground, of course, but we say and seek a finding to this effect that it was an unfortunate lapse of security on his part. He in effect admitted this in cross-examination. Indeed, it'd be hard to deny it, because the fact is he opened an attachment to an email, which was the one thing you don't do when it comes from an unidentified source. We would ask for the further finding that this fraud would not have taken place had Mr. Agarwal been vigilant with his emails and alert to the risk of phishing. In other words, if he had informed himself properly of the risks attending a business like his, had been careful not to open any unidentified attachment, and had not let the status of administrator remain with himself. This is something on which I cross-examined Mr. Siman, and he agreed with me, I think, that the proper course would have been to pass that over to an IT professional who would then deal with it. Certainly Mr. Amin, that was the effect of his evidence. It was a very risky thing, as we see, to have retained the administrator status and thereby enable the hacker to manipulate the entire system. And this is not an issue of system security. The claimant company had got that in place with the Symantec and the antivirus modules, but it left its email completely vulnerable, and both Mr. Agarwal and his expert witness in effect admitted this. On our evidence, and it was confirmed by Mr. Siman, two-factor authorization did exist at the time in Office 365 and could have been activated without any additional investment. In the light of those factors, we ask for a finding that the fraud took place because Mr. Agarwal was not vigilant with his email and suffered himself to become a target of phishing. Number 9, we invite Your Honour to say, notwithstanding tangential suggestions by the claimant that in some way Mr. Sangeet already knew about the Rito invoice when Ms. Zuberi spoke to him on the phone, that evidence is not substantiated in any way. It's simply hearsay evidence, and it depends on the court reaching a conclusion, which is impossible to reach on the evidence before it, that the phone call may have taken place, or the emails sent, on one time zone or another. Your Honour may think it.
Stuck with I do not understand, and I seek your assistance, why this matters. Ms. Zuberi does not say she asked about this. She telephoned about a different matter.
Yes.
And if Mr. Sebastian knew of the first FPR on his evidence, he didn't see a problem with it, not at that time.
Yeah. Well, I mention it because yes.
Why should he have said anything? Maybe he was negligent in that he should have seen a problem with it, but it seems quite clear that he didn't, because that's Aegis's case. He was negligent because he didn't.
Yes.
Why does it matter?
I'm answering a point that perhaps I don't need to, because the impression that I gained, perhaps wrongly, was that it was suggested that in some way the bank had acted in bad faith because it knew of the request but didn't mention it during the course of a phone call. If Your Honour is not going to make any finding to that effect, then I can, of course, leave it.
Well, if that is the proposition, and it's never been enunciated, namely that he knew of the payment instruction request but didn't mention it, well, why would he if he was asked about the closing for the Eid holiday? So
yes,
I'll leave it to Mr. Doherty to respond to it, but at the moment I cannot see that it matters one way or the other.
No. Well, I'm happy to move on. In point 11 in the findings that we seek is that in the way it sanctioned the payment requests, the bank, whatever criticism can be pointed at its at the scrutiny or the level of scrutiny it employed, it was acting in accordance with its customary practices, and I think we can see that must be right, because there were the witnesses themselves have told the court that they didn't suspect anything was amiss, and they carried on as they would have done, referring it through the 5 layers of review within the organisation before it was sanctioned. So, lest it is suggested that the bank slipped up in some way, we answer that by saying and seek a finding to the effect that the bank did act in accordance with its customary practice.
Well, isn't it suggested the bank slipped up? I thought that was the whole point of it.
Well,
I mean, who could?
What I'm saying is that the bank didn't process the payment request in the way it ordinarily would. Yes, it is said that the bank failed to notice the obvious, but clearly nobody at the bank did notice anything amiss about the payment request. They thought it was perfectly legitimate. They saw the signature of Mr. Agarwal and believed it to be genuine. And so I'm asking for the court's finding that, in fact, they did believe it was genuine. It's easy for us now to be wise after the event and impose a higher duty on the bank than circumstances called for. Fact is, this facility had worked perfectly well for a number of years, and the bank has other transactions to deal with in the course of a day. You've heard from the witnesses about that. Finally, on findings of fact, we do ask for a factual finding on causation, because we say the immediate effect of the FPRs, the fraudulent payment request, was not to inflict any financial loss on the company, but simply to cap its TR facility at a lower number, 9 million rather than 10 million, with no discernible impact on deal flow. And it didn't disrupt.
But Mr. Duckworth, can't we not have a bit of common sense here? The bank wants to be paid the $1 million.
Yeah.
That's a liability which the bank asserts.
Yes, I'm saying it didn't inflict.
That's a loss. Are you saying that if it has to pay, that if it pays, that's not a loss caused by the default that is alleged?
If the bank has to pay, that is a loss, yes, to the bank.
No, if Aegis has to pay. If the bank stood up this minute and said, you needn't repay the $1 million, forget it, all right, there's no loss. But I don't think it's doing that.
I think what I'm saying is this, that there wasn't any immediate financial loss. That's what I'm saying. That at a later point, the bank debited the customer's account with the 2 sums, and when it did so, it did entirely as it was entitled to do under the contract with the customer.
But the bank is requiring repayment.
Yes. Well, Ronald, the liability arose when the bank debited the client.
For the declaration that we talked about, isn't it?
Yes. What has happened at the moment is that the bank has debited the customer's account with the 2 sums, and so as from the date of the debit, then the liability exists. There was a gap in time, there was a break, and a new event, namely the bank acting in accordance with its contractual rights. We say that that breaks the chain of causation.
That is complete nonsense, if I can be so bold.
Well, I'll leave it there. I've made my point, albeit it doesn't sound as though I made it successfully.
That's a fair statement. But may I take up another part of this paragraph numbered 14,
Yes.
You put the proposition that the immediate effect was simply to cap the TR facility with no discernible impact on deal flow. Now
Yes.
that comes back to this question of the loss of use of the facility.
Yes.
If Mr. Agarwal said, because it was capped at 9 million rather than 10 million, I therefore had $1 million less than I thought I had, this affected my capacity to make deals, then that would be, then if that were correct, that
Yes.
would be a loss, would it not?
Yes.
Okay.
Yes.
So,
I need to
so
examine
come
that.
back to looking at that that material.
Yes.
All right. Thank you.
Thank you. Coming to the legal issues, this brings me into Quinscare territory. On Mr. Doherty's first main point, that if the bank acted, as he put it, outside the terms of the facility, then its risk of any sums advanced. We're unsure where that argument is going, because is it the case that if, for example, the customer put through a genuine payment request to the bank for, let's say, mining operations, it wasn't a spoof one, it was a genuine request, and the bank passed it, that then the bank would be unable to recover those funds because it was acting outside of the terms of the facility? That seems very strange. We say that any departure from the terms of the facility which is not established was minimal, and it was within the general purview of the facility, the goods, because of the expression goods and services, and because of the earlier expression procurement. Now, the submission that the Quinscare duty exists is, we say, based on a misunderstanding of the nature of that duty and when it comes into being. A critical feature of all of the reported cases under this head is that the bank is holding money on behalf of the customer. In other words, it's the customer's money. The customer deposits money with the bank, and then the bank owes the customer a duty. That's simply common sense. Equally, if it's simply an operation of a current account where the bank pays out money on a check that could immediately cause damage to the customer, then the duty of care exists. But where the situation is reversed, and you have the bank making, in this case, $10 million of its money available to the customer, that's a very different dynamic. And it's not possible simply to say that a Quinscare duty comes into being on the part of the bank at that point.
Why? First of all, do you have some? Are you aware of any authority that makes this distinction? That is a previous case dealing with.
Well, I know of no previous reported case where Quinscare was discussed, and there was no money of the client that was at stake. I say that with one qualification. In the Quinscare case itself, the person who was liable to suffer was the guarantor. You may recall that a chain of chemist shops was going to be purchased, and Unichem, the chemist's chain, stepped in, as they often did, to offer a guarantee to the manager of the business that proposed to acquire the 4 pharmacies. That was acceptable to the bank, and a loan of £400,000 was made to the customer. But the customer, that money was misappropriated by the director of the company and sent abroad. The company then went into liquidation, and although the liquidators had a nominal role in the case and appeared by counsel, that they were financed by the guarantor, and the judge knew that what he was effectively dealing with was the guarantor's pocket. And so it was in that context that he assessed the bank's responsibility to its customer, which would redound to the advantage or disadvantage of the guarantor. In fact, as Your Honour will know, the guarantor failed in the case, and a full judgment was given against the first defendant, the defunct company in liquidation, for $690,000 or thereabouts, which the guarantor would have to pay, so that he was jointly and severally liable. Unichem was jointly and severally liable. So, with the exception of that case, all of the other reported cases where Quinsker has been considered have been where the customer has deposited money with the bank. I can
Now,
take you.
Why, as a matter of principle, does it matter whether the money which is paid out negligently, let's put it as shortly as that, is money which is owed by the bank to the customer on a current account, or money which the bank has agreed to lend to the customer? Why, as a matter of principle, does it make a difference?
Well, for this reason, that when the bank lends out money, then the customer is under a common law duty to exercise reasonable care in the use of the bank's funds. Conversely, when the customer deposits money with the bank is under a duty to exercise reasonable care in its custody of it.
Why is the customer under a duty to exercise reasonable care with respect to the bank's funds? That's a proposition I would need some support for.
Yes, well, it is present in authority.
Yeah, please tell.
Yes, for example, the Greenwood case, which I note at paragraph 19 and 20. I think it's in Your Honour's bundle at G61 and following. The facts are briefly set out in paragraph 20 of my note. That husband and wife here had a joint account with bankers who undertook to honour cheques signed by the husband. The wife, however, repeatedly forged the husband's signature and drew out funds for her own use. He became aware of the practice but said nothing to the bank for a while. And it was held that he owed a duty to the bank to disclose the forgeries when he became aware of them. His failure to do so meant he was now stopped from asserting that the signatures were forged and was not entitled to recover.
Well, wait a minute. And what was the money that was paid out on the forged cheques? Was it current account money?
It was money from an investment, as I recall. I'll need to refresh my memory of the case and perhaps come back to you on this. But I think from recollection, some £140,000 have been paid into the bank for the benefit of the husband and wife, and the wife drew most of that out for her own purposes.
That does not seem to me to support proposition.
No, I may have.
Your proposition seems to be where it is borrowed funds as distinct from current account money. The customer owes a duty of care in some way you described as looking after the borrowed funds for the bank. That I don't think Greenwood supports that.
I'll just a moment, Ron. I'll need to check the report of that case. The reading from the head note, the husband and wife had a joint account with bankers who undertook to honour cheques signed by both customers, and then the account was closed and the account was opened in the sole name of the husband. The wife continued to forge signatures. I think I'm wrong in saying that the customers deposited money with the bank. Let me just check that point. It was a straightforward current account.
Yes. It may not matter because we are really not concerned here with any duty of care owed by Aegis towards the bank. We are really concerned with the reverse, and there either is or is not a duty of care.
Well, I say we are concerned with the duty of care in ordinary circumstances of Aegis to the bank, but it's highly unlikely that a duty exists under Quince Care from the bank to the customer where the bank is lending its own funds.
Well, back to my original question, why as a matter of principle is that so, where the bank is lending the funds so that they end up as a liability of the customer?
Yes, well, the bank is taking a risk with its own funds. And obviously that risk is heightened if the customer doesn't safeguard the money or use it properly. If the customer, for example, in the Greenwood case, if the husband allows his wife to forge checks and doesn't tell the bank, then he's not exercising proper care over the bank's liabilities.
So does it follow from your submission that the bank can be as negligent as it likes with its own money? It could say to itself in the present case, goodness me, this is a terrible transaction. It's hopeless. We are quite convinced that Aegis is being defrauded. Nonetheless, it's our money. Okay, we couldn't care less. We'll pay it up. Does that follow from your proposition?
No, I don't think I put it quite as extremely as that.
Well, I did put it extremely, but the point of principle, I think, is made, is it not?
Well, the way it's put in the authorities is that the bank has to act in good faith. Provided it acts in good faith, then it is not liable.
Well, but if your proposition is right, good faith has got nothing to do with it. It's its own money. It can act in bad faith if it wants to.
No, there's obviously got to be a limit.
The question of asking whose money is, it seems to me to be wrong.
Ron, I repeat the point, and I will amplify it by reference to the decided cases under this heading, that the duty that the bank owes to the customer is always in cases where it holds the customer's deposited money.
Yeah. Well, are you aware of a case of a situation where the bank is lending money and it's been said it does not owe a Quince Care duty? Has there been such a case?
I don't know of such a case, but nor do I know of a case where it is said the bank possibly does owe a Quince Care duty where it's lending money.
Okay, well, as long as we know that if one knows there is no authority, I suppose one's state of knowledge is advanced.
What we do know is that in some cases, the customer does owe the bank a duty.
All right, well, let's move on from this. You did say you would support it from the cases, but I'm not too sure that you can because there aren't any cases.
Well, yeah, I can support it by omission in that I can demonstrate that on the reported cases, as I say, the bank was always dealing with deposited money by the customer.
Well, so let us accept that as a proposition, but it may be something that I would invite Mr. Doherty to double check, please. And if and within a week after we adjourn, if there are any cases outside that parameter, I would like to be informed of them by either of you.
Yes.
Yes, Your Honour.
I'm sorry.
I think it might be a point I can pick up and hopefully draw a line under and reply, but we can try and address that when we come to it.
Because it's arisen fairly lately, then if you want time, you shall have it. So carry on, Mr. Duckworth.
Yes. I mean, in Tai Hing, for example, there the bank allowed 300 forged checks to be drawn from the claimant's account by a known dishonest accounts clerk, and this lost the claimant 5.5 million Hong Kong dollars. So in those circumstances, clearly the bank owed the customer a duty. In the Singularis case, which Mr. Doherty relies on, this was a massive deposit of $204 million following the sale of a business. And that was placed in a segregated client account by the bank, but then the bank paid it out to a dishonest person. That was a misappropriation of the company's funds that had deposited the money, and plainly, in those circumstances, a duty was owed to the customer by the bank over its funds. Those briefly are some of the authorities that I rely on. Now, in relation to the red flags that our learned friend deals with, we say this, that first of all, it's easy to speak with the benefit of hindsight and to ignore the day-to-day operations within a bank which was transacting a number of these transactions on any day. Now, the evidence given by the bank's employees is simply this, that they believed, and nobody is attacking their good faith, they believed that the invoices were relating to advance payments, and so would not be supported by the usual documents of title. As regards the need for a D&B report, this primarily relates to the credit of the customer, as I think Mr. Maniram told you, and it was customary from time to time to seek such reports and to request them of the borrower. But this was never a condition precedent of the transaction going ahead. It was sufficient if the customer said, "We will supply later." An example of that, of course, is at page E303 that we looked at a number of times. It was said that the reference to mining operations was suspect, but we know that that the claimant is a company dealing in minerals, and it was not therefore far removed from its core operation. It was said that the cutting and pasting of electronic signatures from an earlier shipping invoice should immediately have raised a red flag, but the defendant's witnesses told you that they had an intranet system and it wasn't able to validate electronic signatures. So it was therefore not the practice to look at them. There's no utility in looking at electronic signatures since they couldn't be validated. So what this comes to is an allegation, effectively, that they ought to have really put on their forensic hat and looked closely at the document, closely enough to spot that an electronic signature or a copy of an electronic signature had been applied from an earlier transaction. And with respect, that's putting the duty on the bank far too highly. in terms of how the Quincare duty is expressed, we respectfully say that a useful and, in a sense, comprehensive definition is given in the, give me just a moment. I seem to have lost my place. I may need to just ask a moment or two to refresh my memory. Yes, here it is. In the Phillips and Barclays Bank case, this is page 8 of my note, that if you, contrary to my submissions, find that the Quincare duty arises, then the best summary is given by His Honour Judge Russon in the Phillips and Barclays case at page G510, that the primary obligation of the bank is to treat the customer's mandate at face value, and then if the bank does not have reasonable grounds for believing there is a fraud, it must pay. And thirdly, a bank is not required to act as an amateur detective. All of those propositions appear on the same page of the law report. And quite simply what we say is happening here is that there were conflicting duties at best. The bank, if the Quincare point is taken against me, had some obligation to look after its customers' funds, but equally it had an obligation to honour the mandate. And it wasn't duty bound to inquire unless it had reasonable grounds for believing there was a fraud. It wasn't required for those purposes to act like an amateur detective and put on a forensic hat to spot what may seem to us in this courtroom after several days of examination to be indicators of fraud. Your Honour, I refer also to the DIFC law of obligations, and we say that in the light of the fact that the bank was lending its money to the customer, and a large sum of money, then it was reasonable for the bank to seek to protect its position by indemnities and so forth. And in this context, Article 55 of the DIFC law of obligations refers to voluntary assumption of risk. And you saw in the account opening letter how the claimant did voluntarily assume risk by giving its signature to a document that said as much. That the claimant would now like to row back from that and say, well, that was not reasonable, but it was reasonable in the context of a case where the customer hadn't entrusted his own money to the bank, but the bank was entrusting its money to the customer. Then at page 11, I summarize at some length some of the main propositions that come out of the Quincare case. And I think the simplest way is simply to just refer Your Honour to those points there.
This is A to L, other ones.
A through L, yes.
Just give me a moment, John, I'll read it, because as I said, I haven't properly read this before. Yes, thank you.
Your Honour, at page G312 is a recent decision of the Canadian courts on the position where a fraudster breaks into an account and gives a counterfeit instruction. So, although perhaps a decision of the Superior Court of Justice in Ontario is not binding in this country, nonetheless, it is a persuasive authority and is based on common law principles. May I take Your Honour to G312?
Yet again, I have been logged out, so I'm sorry, there'll be a short delay. The page again, please, Mr. Duckworth.
Yes. Page G312.
Thank you.
The reason this is instructive is because it's very similar facts. It is a case of fraudulent phishing, and it's a decision of the Justice of the High Court in Ontario. The plaintiff was seemingly a Chinaman, Yong Shengdu, and the defendant was a bank. The claimant conducted various investment activities through the bank, but at the time of opening his account with the bank, signed terms and conditions, the relevant parts of which are set out on page 3 of the report, paragraph 9. And like this case, there was a clause entitling the bank to rely on a variety of modes of communication which they believed to be genuine. Precisely the same formulation, really, as we have in this case.
Mm-hmm.
And under your responsibility, he agreed that it was his responsibility to maintain security systems and so on to prevent fraudulent, unauthorized instructions by anyone who's not an authorized person. My argument on that would be that the letter of indemnity had really precisely the same effect by saying that the bank could act on what appeared to be an authorized person, and that the customer absorbed the risk of fraud or impersonation. Paragraph 11, just like Mr. Agarwal, Mr. Du admitted that he alone could impose security protocols on his electronic communications, and that he was solely responsible to protect the integrity of his email account. That's a very similar position, because of course the person who allows the phishing to happen is the one who has the power to do so. Then there is something about the history of the transaction, and the long and short of it is that the claimant was duped into transferring paragraph 24, the sum of $45,000 to a bank in Singapore to an unknown stranger. That was a phishing email from an address on Hotmail, which the bank treated as genuine and complied with. And then a few moments later, no, I think it was the next day, paragraph 27, a further message came from the fraudster requesting the bank to transfer $90,000 to Singapore, the same account. Mr. Du didn't find out about this for a little while, but of course when he did, paragraph 30, he realized his email had been hacked and that the instructions to transfer to Singapore were unauthorized. He couldn't explain in cross-examination how the alleged fraudster would have known of his details, and it rather sounds as though he, like Mr. Agarwal, he opened an attachment that gave away that information to the fraudster. So what was the upshot of the case? Well, the upshot was that the matter was governed by contract. Paragraph 55 and following, the judge said this, that at the time of the critical events, Jamson had a contractual relationship with Du, which could be best described as a creditor and debtor relationship. In other words, that reflects English law. 56, Jamson had a common law and contractual obligation to honour its customers' instructions and was entitled to treat the customer's mandate at face value. Jamson was required to act on its customers' instructions as long as he or she had sufficient credit, and they weren't obliged by the contract to question any transaction which was in accordance with the mandate. So the judge's finding based on that at 57 was that Jameson was merely complying with instructions received from Du via the email address provided by him in his account opening form. And that was an email he often used when communicating with them. They had no reason to believe, middle of paragraph 57, the instructions to wire transfer money from Du's foreign exchange account to Singapore were fraudulent. And moreover, he says in 58, Jameson were acting in accordance with the contract that governed the relations with the customer. 62, on page 15 of the report, the terms of the application and the account agreement are clear. Du was entitled to provide instructions to Jameson by email address, which he did, and successfully, and he only had the responsibility and ability to control the security of the email account. Based on those facts, at paragraph 68 onwards, the judge went on to say that the agreement between the parties identified the risks from electronic communications and made it clear that Du, the claimant, assumed the duty of care in relation to that risk. And if the bank were to be found negligent, it would only be in the event of gross negligence or willful misconduct. The judge went on to say in paragraph 70, nothing on the face of those instructions that should have alerted Jamson to a fraud, and that it could have rejected the instruction, or that it should have rejected the instruction it had duly received from the authorized address. He went on to define gross negligence as very great negligence and willful misconduct, and he referred to the exclusion clauses at paragraph 73. For those reasons, he dismissed the claim, and so the claimant walked away disappointed. Your Honour, I would also like to refer to an article by Dentons, who are, of course, are a worldwide firm and have a presence in the UAE.
Is that authoritative?
No, Your Honour, but it's helpful in explaining. I don't invite you to rely on it as authority, but insofar as it explains the basis of the decision, I'd like to rely on it. It's an article called Banking Fraud, the Power of Well-Drafted Documents, and it is in Ronna's bundle at...
I have it.
Thank you.
What is
It's quite...
the proposition in it that you adopt by way of part of your submissions?
Well, it is the second half of the article from the heading Jamson's successful motion. It says the claim in negligence and the request to add other allegations.
Rather than read it, because this can only be looked at as a submission by you. Yeah. What is the submission that you make in your words?
Well, the submission I make quite simply is that the extent of the duty of care owed by the bank is governed by the contract between the parties.
Yes.
It's free, they're free to modify that in any way they wish. All of the, with the possible exception of exclusion clauses that don't get off the ground for whatever reason, usually for reasons of construction, the basic proposition is that all of these duties are capable of moulding or modification by contractual arrangements between the parties. And therefore, I rely, of course, as I have done, on the terms of the various documents that are set at the front of the H bundle.
Yes. Can you just, I would like you to enumerate 1, 2, 3, 4, 5, 6, the precise clauses that you rely on, please, just so that I can make sure I deal with them all and nothing more than I need to do.
Yes, well, I rely on the whole of the indemnity letter.
No, you don't. You rely on the particular provisions in it that you will identify.
Very well. Just allow me a moment to call it back onto my screen. Well, in the letter of indemnity, we rely on the first unnumbered paragraph, which talks about fax or any other electronic communication. On paragraph 2, the bank is under no obligation to identify the party or the purpose or the payee of a transfer.
So number 1 is the words, the bank is under no obligation to identify the party giving the instructions.
Yes.
That one?
Not on that sentence, but in words that follow, the bank is not obligated to inquire as to the purpose of any transfer or the identity of any transferee.
Well, right. I want to be precise. So the first, quote, exclusion, unquote, that you rely on is to be found in the words, the bank is not obligated to inquire as to the purpose of any transfer authorised for any such instruction or the identity of any transferee. Correct?
Yes.
Okay. Now, second one.
Did you take on it? That was the second one. The first one was the heading of the letter, which said that the bank may accept instructions by any other electronic communication acceptable to the bank. Perhaps that goes without saying, because we know that all of the...
Well, that simply describes when the exclusion will operate, doesn't it? So you've got to jump that hurdle, and then you rely on the exclusion, which is thereby triggered.
Yes.
Is that right?
Yes, that's right.
So number 1, you've just identified. What's next?
Number 2 is paragraph 4. I'll confirm to the bank in writing any instructions given, but failure to do so won't affect the validity of transactions executed in pursuance of those instructions in event of any inconsistency, etc. We further agree not to hold the bank liable and hold the bank harmless and fully indemnified from all transactions executed by the bank in pursuant to either of them.
So number 2 is we agree not to hold the bank liable and to hold the bank harmless for all transactions executed by the bank pursuant to either of the things referred to earlier.
Yes.
That's the exclusion.
Yes, either an instruction or a written confirmation.
Yes, thank you. I understand that.
Yep.
Okay, number 3.
3 is over the page, number 5. From the well, it's got to be read as a whole, but perhaps the critical words are in the 5th line from the bottom, we agree to bear all risks in relation to any discrepancies or errors in the figures or instructions or messages as a result of any malfunction of the fax machine or misunderstanding or lack of clarity of such instructions.
Well, hang on, just stop there. Do any of those words matter in this case?
Well, it's marginal, but lack of clarity would perhaps avail the bank.
All right. Okay. So far as it refers to lack of clarity.
Yes.
Yeah,
and then importantly, yes.
Right. So that we can treat that as number 3. We agree to bear all risk in relation to lack of clarity.
Yes.
And number 4
is the remaining words in this paragraph. We further agree that the risk of fraud, forgery, or fraudulent impersonation shall be borne by me/us.
Yes. Right. I understand that. Thank you.
I go to the root of this case. And then 7. I think I'm up to 5 now. There's 2 aspects to paragraph 7. First, that we unconditionally agree to indemnify the bank against all actions, etc., which may arise from any loss, etc., incurred or suffered by the bank of whatever kind, arising out of or in connection with such instructions. So the indemnity flowing from the instruction.
Well, you say that in your case, that's a circular indemnity, is it? If you have any liability, then it's cancelled out by the indemnity.
Well, it's not just liability, it's actions, claims, or demands. It's wider than just liability. If it were just liability, yes, it would seem to be circular, but
well, but the only question here is liability.
Well, by reason of the bank following instructions, what it believed to be instructions, harm has been caused. Now, who bears the brunt of that? Is it the bank or the customer? And by this contractual clause, the customer carries the can.
Well, query whether that is what it means, but that's what you get from clause 7.
Yes, I do. Yes.
It's number 5.
That's number 5. Then number 6 is that what has actually happened in this case, that we also agree that the bank may, without further notice to us, debit any of our accounts with it and reimburse itself in respect of the aforesaid losses.
Okay, that's number 6, yes?
Yes, that's right. And just to emphasize the point, you'll see on 2 pages below that, E9, is the signature of the person who's called the authorized signatory. Now, moving on to the facility agreement, the relevant facility is now the 2018 one, but this was simply a letter for renewal, and it referred back to the 2017 agreement, which was extended for a further year, covering the period in question. So it's necessary to go to a number of features of the facility agreement in 2017 at page E108 and following. We rely contractually on paragraph 2.4, page E12.
Yep, right. 2.4, that's number 7.
Thank you. So just commenting on that for a moment, lender not bound to monitor or verify the application of any amount. This is the answer to my learned friend's point that the bank was under a duty to ensure that whatever transaction was put before it was in accordance with the limited facility. We say that that's not right. It's the customer's responsibility to ensure that it complies with the facility. The bank isn't bound to do anything except it can monitor if it wishes. That's a matter of discretion, as the bank's witnesses said. It's of course a common provision in any loan agreement when you have a purpose of the loan is stated, but it is said that the lender, although that's the object of the facility and that's the purpose for which it's granted, the lender isn't bound to monitor that purpose and see that it's complied with. So it's a one-way liability. Liability is not the right word. It's a one-way responsibility of the borrower, as indeed you would expect. Next, paragraph 18.1 we rely on. That is communications to the borrower. And then 18.2 is the one we've discussed. It's the more, it's the one that has an element of ambiguity to it, because it seems in the first instance to refer to formal notices, but then it goes on to say any communication or document to be made or delivered in accordance with this agreement.
This is machinery, however. I'm looking at what I have called in quotes the exclusion clauses on which you rely.
I'm not sure that's the right nomenclature. I mean, some of them are simply ordinary provisions in a loan agreement. For example, the not bound to verify the use of the facility.
Yeah, well,
but I suppose they can be sort of grouped together.
Let us call it the allocation of risk provisions.
Yeah, yes, that's
so we've got
right.
Number 7, and
Yes.
I'm assuming you're going to get to 18.6 or 18.7.
Yes, we rely on both 18.6 and 18.7. 18.6 is the substantive authority for the account signatory to send effective communications requiring something to be done. That we respect to submit that the object of this clause is wider than simply formal notices, for example, of terminating the contract, and it extends to any other communication made by fax or email, which is signed by the authorized person.
But I thought I identified 18.6. You are now talking about 18.2, which is not an allocation of risk provision.
No, I'm looking at 18.6. I'm sorry if I didn't make that clear.
Well, you do rely on 18.6, though, as we call it number 8.
Yes.
All right.
And 18.7, lender entitled to act in accordance with any email as such as referred to in clause 18, and borrower shall indemnify the lender, etc.
Okay, so that's number 9.
Yes.
Are there any others?
other than the routine renewals of credit, Ron, no. The
What
supplemental
do you mean
agreement,
by
we say
that?
them to add. Beg your pardon?
What do you mean by that?
Well, the renewal of credit, for example, E291 was by letter from the bank, saying that this facility is renewed for a further year. So that doesn't significantly add anything.
Well, it just means that they are in force at the relevant time,
Yes.
or whatever
So
they have.
It continues the force of the 2017 agreement into 2018 and 2019.
Right.
So the facility agreement plus the renewal letter completes the picture, as it were.
All right. Okay.
Uh,
All right. Well,
those are the contract provisions.
thank you very much. Yes. All right. Back to your submissions to complete them, perhaps.
Yes. I turn to contributory negligence. In a sense, I've already said what I need to say on this, but to us, it seems obvious, and we submit to the court. It should seem obvious to the court also that anybody who managing a business of this size and transacting significant sums of money on virtually a daily basis must exercise care over the administration of his email accounts. As the expert put it well, really, if it's not just a case of a business selling goods, it's a question of a business which relies on email to effect substantial transactions. And so the security of the email system is crucial. Now, Mr. Doherty says, well, the claimant did what it could. It went to an expert and took advice and followed that advice. But we're not talking about that. We're talking about the response, even instantaneous response to a phishing email, which it may be quite innocently opened by the bank manager, but by the managing director. But the fact that he was A, unaware of those risks, and B, fell into the trap, is itself indicative of negligence. It speaks for itself. And if, as was inevitable, damage followed, then it's simply not possible for the claimant to escape some responsibility. We would say substantial responsibility for what happened. The bank may have, on one view, contributed to that situation by, as it were, furthering the instruction that it believed to be genuine. But the instruction came from the claimant in the first place, and the claimant cannot simply slough off responsibility for that. One's not talking about negligence over a long period. It can be within a matter of minutes that the damage is done. But as is the need of the hour, so the care that has to be taken is adjusted to it. Now, it is clear that if the court is in a position to apportion responsibility for what happened here, and if you're against me on my primary submission that the bank is not in breach of duty to the claimant, then I invite Your Honour to apportion liability in a way that is just and reflects the part played by each party to the fraudulent transactions. Mr. Agarwal may say, well, I was innocent, but so did the bank officials. They went through their ordinary due diligence processes. It failed to detect what was a very sophisticated phishing attempt on any view. The court's ability to apportion damages or responsibility is independent of the contractual duty. It can simply do what is just in the circumstances to reflect the conduct or the interests of the parties involved. Of course, the the fact that the bank is a financial institution and the claimant is a trading company has nothing to do with that. It's simply a question of evaluating the contributory factors that led to loss in this instance. Now, on the final point of quantification of loss, I confess that I haven't addressed my mind to this. I was surprised to hear that it was still being persisted in, because we were under the impression, perhaps falsely, that it wasn't being. I will now need to go back to the evidence on this, and I would appreciate the opportunity, Your Honour, to do so and address you for 5 minutes after I have had that opportunity.
Well, Mr. Doherty perhaps can provide the evidentiary reference that was missing before. This is to where Mr. Agarwal gave his evidence of loss from loss of use of the facility. At least as I understand it, that's the proposition.
Sorry, yes, Your Honour. Sorry, bear with me. I've been through the evidence. I think, as best I've understood it now, what Mr. Agarwal is relying on is what is set out in his amended particulars of claim, verified by a statement of truth signed by him, and the fact that on the claimant's case, the quantum issues don't appear to have been disputed in the defence. So if we look at the defence, it's 98.3 of the amended defence at A265, in which, let me just get the page reference for me, in which the response to this head of claims, as the claimant in subparagraph B, paragraph 108 of the amended particulars, stresses that the credit facility limited was eroded by the defendant due to the first two payment transactions made to Rito and Camera Robotics. And the claimant has been unable to access those limits and has been prevented from trading as normal. In response, the defendant submits that it is no liability for the claimant's consequential losses, if any, for the following reasons. One, the fact that the authorised email ID was hacked without knowledge of the claimant for a long time. Two, owing to the non-cooperation of the claimant in investigation procedures. So in my submission, there is no issue taken as to the sums quantified in the amended particulars of claim.
Thank you. I'll need to take instructions on that, John, because I haven't given active consideration to this part now.
What I think might be desirable is to take another short adjournment now, and would that assist you, Mr. Duckworth?
Yes, I think so, Your Honour. I just need a few minutes, I think, to see what our position is, to understand it.
Yes, indeed.
Thank you.
Your Honour, if it assists, I don't think that I'll be terribly long in reply. I've got some to say, but I'll make them shortly. So that might give you a steer of the break you want.
Yes. Well, I think that might be the best course. So we'll resume in 15 minutes. Mr. Duckworth, if you could tell us your position on those all three of those quantum matters. That's the well, actually, the $60 hasn't been mentioned, and let's not worry about that, but we'll spend more money talking about it. It's the management fees and the loss of use of the facility that I need some further assistance on, please. All right, I'll see you in 15 minutes.
Thank you.
Chairman, are we
Yes.
on to resume?
No, I think I've found the answer to my question at paragraph 98 of the amended defence, page A265.
Yes, which part of a very long paragraph 98?
Yeah, it's 98.3, and then we can scroll down to little c at the foot of A265, which begins, the claimant at subparagraph C108, amended particulars, makes a claim for 84,580 expenses, seeking to resolve issues. Sorry, that's my alarm clock going off, apologies. And that's split into management time and some travel expenses. The defendant denies any liability in respect of the same. Calculation for management time and travel expenses is unsubstantiated. So, Ron, it seems that the pleading certainly clearly put that in issue. And it goes...
That is management time. The one that Mr. Doherty referred to was loss of use of the facility.
Right. Yes. I can't see there. No, I can't see a response to the loss of use claim of the facility. We would say that this is not really capable of substantiation anyway, because the trade of a company like this fluctuates, and it's very difficult, extremely difficult to measure the effect of a loss of a relatively, well, a small proportion of the facility on the overall business. I don't know if Your Honour will allow me to develop this submission or not, because you may say, well, we haven't dealt with some pleadings, but...
Well, I do not know at the moment what the pleading says about it. I'm hoping you might take me to it.
Yes. No, I can't take you to that. I can't see that it deals with it. And
well, 28.3b deals with it, doesn't it?
Let me just have a look.
That I think is what.
Oh, yes, it does. That's what I'm. Yes, I'm sorry, I missed that.
The question then is what that means. It would be most unfortunate if we end up in an arid pleading argument here, but it looks as if we are.
Yes, I can't really see that it deals with the quantum of the claim. It denies liability for the claim for consequential losses for reasons that look like they are to do with issues of contributory negligence and failure to cooperate with the investigation procedure. Now, it has been.
Yes, that leaves you.
I'm not quite sure where that leaves me. I know it is part of our case that Mr. Agarwal didn't cooperate and unreasonably refused to do so, and there's an issue between the parties about that. But I'm not being of much assistance, I fear, to the court on this issue of the loss of use of the overdraft. Your Honour, as an annex to my first skeleton argument in this matter, I did provide an analysis of the movements in the overdrawn account, and it was certainly not always utilised to the full. There was frequently a time when the balance fell below 7,500, for example. It fluctuated, as you would expect. So one would have thought that it's extremely difficult to measure over time the alleged loss of use of part of the facility. I would, I think, wish Your Honour to see, if you have a copy of my skeleton argument to hand, just to go back to it and see what it says on this.
Yes, I have that. Whereabouts am I looking?
It's the very end, Ronald. There's 2 pages.
Yeah.
The first gives an indication of the balance of the facility at different times, but it isn't a comprehensive statement of the balance. One would need to actually look at the underlying documents to see how it fluctuated. The ins and outs are set out on the next sheet, Annex 1.2, and what one can see there is, well, it's really quite difficult to know. We haven't actually been shown any bank statements post the 20th of June 2019, and so it's really quite impossible. Sorry, the 17th of July 2019 is quite impossible to know what trade, if any, was lost. However, Your Honour has some indication on the Annex 1.1, because if you look at the bottom of that sheet under summary transactions, you can see the in and outs of the account over different periods. And looking at the last of those periods, the 20th of June to the 17th of July, it doesn't look in any way as though there was any fall off of business. It continued as before. It would be my respectful submission that the...
Tell me anything about the business.
No, well,
You had other banks.
You haven't been told about the business and what effect it had.
Well,
What I say,
Mr. Duckworth, I'm really most unhappy about this. The starting point is that Mr. Doherty says, as I understand it, I have no evidence in support of this claim except for the couple of lines at the end of the amended points of claim and Mr. Agarwal's verification of truth of those points of claim. Am I right, Mr. Doherty?
Yes, Your Honour. In respect of the, yes.
Question 1, therefore, Mr. Duckworth, is that evidence at all on which I can act?
no, because it's been put in issue, I would respectfully suggest.
Well,
there hasn't been any inquiry into damages.
That's not an answer to the question.
I'm sorry, would you kind of repeat it?
Put in issue is irrelevant to whether it is capable of being evidence on which I can act. The first question is the verification by a statement of truth of the allegations in points, particulars of claim, evidence at all? What's your answer to that?
Well, in my respect of submission, no. It's simply a verification that is the pleading. It's stated to be true, but it's not. It doesn't have the same effect as a witness statement.
Now, Mr. Doherty, do you say that there is evidence of something?
Your Honour, I think I'd put it slightly differently, which is it is a pleading point. The loss of profit was pleaded and claimed. It has only been disputed effectively on the merits. That's what 98.3b is. And so given that the sum is undisputed, from a quantum perspective, then if Your Honour should decide in favour of the claimant on the merits, then that would follow. That's my position.
So you don't rely on the verification as evidence. You simply say, as a matter of pleading, an allegation has been made which is not contested. It is therefore admitted.
Yes.
Is that your position?
Yes, Your Honour.
Right. Now, is that right or wrong, Mr. Duckworth?
That's wrong, because paragraph 98.3 of the amended defence, the claimant, the defendant, just quickly rereading that, submits there's no liability for the losses, and says in little c that the calculation is unsubstantiated. So one way or another, those items are put in issue in the pleading and also in Mr. Maniram's witness statement.
I'm sorry, you said something about the calculations are in issue. Would you point that out to me, please?
Yes, on the next page, A266.
That's management time and travel expenses.
Yes,
That is not what we are talking about.
no. But I would respectfully submit that the claim for loss of use of the overdraft has never been particularised to the extent necessary for the court to act on it.
That's irrelevant to the question of whether there has been, on looking at the documents, an admission on the pleadings.
Well, there's certainly no express admission.
If you would concentrate on the question, please.
Well, our submission is that there is no admission on the pleading.
Very well. Now, why not? And then we will move on. I will simply have to decide on the basis of what is put forward.
And I can't say that in 98.3b there was a challenge to the quantum, but to the entitlement.
If any are an implied challenge.
I would respectfully say it is an implied challenge to the quantum as well as to the liability, but I can't really take it further than that.
Under the pleading rules, assuming there is not a traverse of the allegation in the amended particulars of claim, is there an admission or is there not?
No, there's not an admission, Honour.
Why not? What do the pleading rules? Can you tell me?
Pleading rules are they not, that special damage has to be pleaded, has to be quantified.
Well, it is pleaded and it is quantified in the pleading. So that gets you nowhere.
Well, I really can add nothing, Your Honour, but I would say that in these circumstances, the proper course is to, if Your Honour is against us on liability, to refer over the matter of damages for investigation.
Yes. Mr. Doherty, why aren't the words, if any, an implied traverse? Because they contemplate contest. There is anything.
There was a specific pleading on the sums and how they were claimed. I don't think it's sufficient for it to be an implied pleading, because if you are to defend a point, the pleading rules say that you should state the reasons why you deny something if you deny it. So given we've got a case where we have the particulars of loss, which have been pleaded in one way, if they haven't been responded to, I don't think it's enough for the defendant to rely on that sort of catch-all provision.
Yes. All right. Anything else either of you wishes to say on this point?
No.
No, Your Honour.
All right. So your submissions in reply, please, Mr. Doherty.
Yes, Your Honour. I hope to be brief. First point, at the beginning of my learned friend submissions, it was said that the defendant doesn't accept that there was a limit to the use of the facility to any specific goods or purposes. Just a couple of points on that. We say, first of all, it's a clear contradiction to what's set out in the express terms of clause 4.2 of the facility agreement, but it also contradicts the defendant's own evidence. The defendant's witnesses accept that they would look at whether the transaction was within an authorised use, and at least one witness made the point of if the facility was being used to buy a hotel or hotel operations, that wouldn't have been permitted. The second point also relates to clause 4.2a and the reliance that was placed on the word procurement, so the idea of the procurement of goods. That provision does not authorise Aegis to engage in the procurement of goods. What the clause actually says is making payment to suppliers for procurement of goods. So we say that the suppliers in this case have procured the goods and Aegis are paying them for those goods. That's the proper interpretation of that, we say. The submission made at paragraph 17 at point 13 of my learned friend's skeleton refers to the fact that whereas a trained eye would have spotted anomalies, that's not sufficient. We say that somewhat makes the point. The point here is that the staff that work for the bank are trained banking professionals who do undergo training in relation to anti-money laundering and how to identify red flags and suspicious activities. And based on that training, they conduct their review process. So in that context, we are looking through the eye of a reasonable banker, not a layman, and the reasonable banker does have training on those issues, we say. There was an issue which has cropped up a couple of times about the suggestion that if the bank were to pay outside the terms of the facility, even though a request had been legitimately made and authorised by the company, that the bank might not be able to recover sums in that scenario. And I think the suggestion is to make the point that such a scenario would be commercially unworkable or somehow would defy the express terms of the relationship. We say in that scenario, patently, the bank would be able to recover the sums. And there are a number of different ways that you get to that analysis. But first of all, if the customer is requesting use of the facility for something it's not permitted to, the customer itself is breaching the terms of the facility. And the bank would be able to recover any loss it sustained on that basis. The second point would be that if the customer were to try and rely on a scenario whereby it could retain the funds anyway, that sort of claim would obviously be precluded. Well, in a number of analyses, one, it could be on the application of the law of waiver, or as has happened in these check cases, where there's an estoppel that arises. And I'll just give you the page reference, Your Honour, but there is a section on estoppel in Chitty at 34338, which is page G487 for your note. And so we say that argument doesn't really work, it doesn't go anywhere. On the issue that was discussed at some length of the significance or not of this being a TR facility or a loan as opposed to a current account, there are a number of different observations one can make about that. The obvious one is that there's no logical reason why Quinscare wouldn't apply in those circumstances. The purpose of the rule is to prevent the bank from paying out in circumstances where it's on notice of fraud. So where we've got that policy motive effectively, it wouldn't really make sense that it wouldn't apply in the different contexts. There's also the point that on the facts of this case, what happens is that the money goes from the TR account into the claimant's current account, and it's from the current account that it's paid out. So it's slightly unclear whether that sort of argument would be engaged on the facts. There was a suggestion as part of this line of argument that there was a duty of care to take care of the bank's funds where it's a loan, and there was reliance placed on Greenwood. But I think we got to the conclusion that that's not really what Greenwood and Macmillan deal with. Those are about drawing checks negligently. There's no authority for a wider proposition that a customer operates under a different or a broader duty in respect to funds loaned to it by the bank. The obvious duty that arises in that sort of circumstance is the contractual one, which is if I borrowed money from the bank has a contractually enforceable right to get the money back off me with interest. So they don't need that sort of duty to protect themselves. They would just sue under the loan agreement. And the final point, which I think is the very short answer to the question as to whether there is some kind of difference in principle, Quinscare itself was a loan. So in that case, the owner of a company, I think it was, took out a loan of $400,000, I think I might be right in the figures, to open up 4 chemist shops and misappropriated the sums from the loan. So as to the question of whether there is authority for the proposition that a loan should be treated differently, actually the originating proposition of law did arise in precisely that sort of circumstances. The next point is on Do, the Canadian case. There are a number of observations one can make about this. It's on very different facts for starters, which is that we can see in its paragraph 14 to 27 of the judgment, but you can see the back and forth exchanges that are set out at length there between the customer and the bank, in which one can see quite clearly that the messages and forms of communication between what were legitimate transactions and allegedly illegitimate transactions are virtually indistinguishable. And that point was made by the judge. I'll come back to that though. It was also pleaded on a completely different premise. So that was a case which was pleaded on various terms, but it was breach of contract, conversion, I think a heading of oppression, breach of fiduciary duties. And of course it was before the court of first instance in Canada. So we're not actually looking at, in this case, the history and the long line of authorities that are relied on in this case, which is the derivatives from Macmillan and other cases leading to Tai Hing, nor the Queen's Care duty of care. And so we also built into that aren't taking into consideration whether the exclusion clause in those cases was sufficient to exclude those duties which arise under English law but not under Canadian law. There's also a distinction in the exclusion clauses themselves, because in that case they had very clear carve-outs. I think it was for gross negligence, which doesn't apply in the facts of this case. And perhaps most importantly, the factual finding in that case was that there was no reason for there to have been suspicion that the transactions were fraudulent. So on the facts of that case, we're not actually in Queen's Care territory at all, because the bank or the paying party weren't on inquiry. So we're not considering like for like. My submission doesn't assist us, and to some extent it seems as though there may be issues in which it's an outlier when compared with the authorities in the English common law world. 3 points on some of the indemnity submissions, and they're quite short because I've given you my primary submissions on that. On clause 5, and in particular, this is the letter of indemnity. In clause 5 of the letter of indemnity and the supposed indemnity for fraud, that has to be read in the context of where it appears. So it says, we further indemnify in circumstances where the previous sentence is about an indemnity where a fax machine breaks down. So in those circumstances, as your Honour knows, our primary submission is that this is an agreement about fax, and that provision directly follows on from something which is dealing with a specific issue with the technology of fax. Clause 2.4 of the 2017 facility agreement, the suggestion is that there is no obligation to verify the application of any amount. We say that there's an important distinction between verifying the application of an amount and checking the purpose of a remittance. So if the purpose of the remittance says payment for limestone, and the bank is satisfied that the documents of title and so on sent in support show that it does fall within the use of the facility on its face, what it then doesn't need to go and do is to check that the money is actually being applied to limestone in that transaction as opposed to some other purpose. So that doesn't get the bank anywhere in this scenario where on its face the purpose of the remittance was payment of mining operations. So it's a different stage of check. The first is that you check the purpose of the remittance, and then there would be the next step, which is actually verifying the payment of the amounts by checking that they did in fact go on to be applied for the purchase of limestone. Clause 18.6 of the 2017 facility agreement. This relates to effectively the end of that clause, which refers specifically to instructions being received by fax and makes no reference to email. And Mr. Duckworth's submission was to say that it doesn't make sense that the second provision wouldn't also apply to email, and that it would have to refer to email as well in order to make commercial sense. My submission on that is that you can actually look at this the other way around. The commercial sense in this case would be to remove the word email from the former part of the clause, whereby you would then have a provision which makes perfect commercial sense, which is dealing with facts only and then deals with the facts specific gloss at the end of the clause. And we say that based on the principles that this court has to apply when it comes to the construction of exclusion clauses and the requirement for clear words, in this case, the court ought to be giving the benefit of the doubt to the claimant as the party who did not draft the terms of the contract and who isn't relying on it. A brief point on contributory negligence. Mr. Duckworth has suggested, we say at best, hopefully, that there should be a 100% or no less than 75% reduction for Mr. Agarwal's negligence effectively in failing to spot the warning signs on an email. Now, we say that that submission can't really work logically. The criticism of Mr. Agarwal is effectively that he didn't spot certain warning signs on an incoming email. The bank is alleged to have done exactly the same thing, plus a whole host of other red flags that it missed, not only in the email, but in the invoices that were submitted to it, and in the activities surrounding the fraudulent payment request. So it would seem an unusual decision to suggest that Mr. Agarwal bears the lion's share of the fault there. And Your Honour, those are the only points that I have in reply. Unless I can assist you further, those are my submissions.
Yes, thank you. Right, well, gentlemen, I got a little bit cranky with you both on the question of those extra bits of loss, but we will proceed. The one thing that does occur to me, particularly in the light of Mr. Duckworth's repetition of the causation submission at page 8 of his submissions, is that I should deal with it perhaps more in more depth than my rather unkind remark in the course of submissions. And for that purpose, I think I need to know what the state and movements of the TR account was, and the corresponding entries in the current account. Is that in the evidence? Can that be taken out of the evidence in some way?
No, Your Honour, the TR account runs out at the 17th of July, and therefore doesn't cover a period when sums were debited to it in relation to the two amounts outstanding, nor does it deal with when repayment facility occurred. As one would have thought, in any event, the claimant's loss would be capped at the point when it ceases the facility.
All right. So, so your proposition at page 8 of the submissions, at the time of debiting the account sums it's lost, is the proposition which is, as it were, in the abstract, and doesn't derive from referring to the evidence. Is that correct?
Just reminding myself of what I said. Did you refer to paragraph 8 of my closing submissions or my opening discussion, Your Honour?
Closing submissions, page 8.
Yes.
The paragraph
yes.
8. It's the one that sparked this in my mind.
Yes. No, we haven't.
The evidence, I won't ask for any more, that's all.
Well, you have a reference to a... I'm sorry, I'm really troubled this. Paragraph 8 begins on 28/6/17. I'm sure Your Honour's not referring to that.
No,
I think it's subparagraph 8.
subparagraph 8, I beg your pardon. On page 8, start it with in italics causation.
Ah, yes.
It is in the same vein as the paragraph, subparagraph 14 at the top of page 7, which was the one that provoked my unkind remark. And seeing that your proposition was repeated, I thought I should give it more careful attention in what I'm going to be writing.
Yes. I can't at the moment help Your Honour any further on this, save that, as I say in subparagraph 14 on page 7, there is a letter in the bundle at that E1245, which shows the parties were at loggerheads and over the issue of whether the 825 and the 241,500 should be debited to the claimant's account with the bank. My instructions are, yes.
In fact, your instructions are it has been debited.
It has been debited, but the remainder of the facility has been repaid.
Right. All right. Well, that is probably enough for my purposes. Then, if there is no more, I can deal with it on that basis. So, thank you very much.
Thank you.
All right. Anything else from your side, Mr. Duckworth?
In relation to that, the Quince Care matter, Mr. Doty said it was a 400,000 loan, but that rather overlooks the point that I made, which is that the chemists chain, Unichem, gave a guarantee for 400,000. That was the issue. And that's where the duties arose, because the banks, in a sense, the bank's notional duty to the liquidated company, the first defendant, rebounded on the guarantor, who was the second defendant. And so that was the reason why the judge had in mind, I respectfully submit, the effect of either upholding or denying a duty on the bank in those circumstances. In principle, the duty existed, but it was denied on the facts because of the terms of the contract between the guarantor and the bank.
Because of the terms of the contract between the guarantor and the bank?
Yes, yes.
All right. But in principle, it existed between the customer company and the bank.
Yes, yes.
Even though it wasn't advanced by the bank to the customer company.
Yes, but the judge made it clear. I haven't cited from the judgment. The judge made it clear that he was dealing with the position of the guarantor, and that's why he was actively concerned with this issue. Let's see if I've got a reference to that.
Give me that reference, and then I'll obviously have to study it more carefully.
I'm not sure my recollection is absolutely accurate here, but I have a recall that towards the end of the judgment, Mr. Justice Steyn expressed concern about the position of the guarantor and the effect that his judgment would have, and then construed the deed of guarantee only to find against the guarantor that it wasn't covered.
Well, leave it with me then, Mr. Duckworth.
Yes.
I'll have to study the judgment. Thank you.
Yes.
Your Honour, a passage which may assist you, it's at 375 G116, but effectively this is part of the extract that I took Your Honour to earlier when it's talking about what the relationship between banker and customer is. And it's expressed there in broad terms that primarily the relationship between a banker and a customer is that of debtor and creditor. And that seems to apply to what it's suggesting for all banking relationships. And that would seem to apply, in my submission anyway, the same in a loan arrangement as it would in any other arrangement.
Yes. Well, I think I should give you both the opportunity within the next 7 days to submit a note to the registry with any cases that you may find which applied or recognised a quince care duty where, in Mr. Duckworth's terms, the money was the bank's money, that is, it was a loan situation rather than a current account situation, or that you are unable to find any such cases. So perhaps a joint memorandum could be prepared that simply gives the references to any cases found or says that there are none. So
Yes.
if you would cooperate in that sometime within the next 7 days. Thank you very much, and I'll reserve my decision otherwise, which I can assure you, because there's quite a lot to be gone through, will not be. Thank you. Well, I'll now.
Thank you, Your Honour. Very grateful. And thanks to the court staff as well. Thanks, Peter.
Cheers.